On urgent matter, no confidence motion in the panchayat. It was on our application listed yesterday, but somehow it didn't reach, my lord. So can it be taken Friday, my lord?
Thursday?
Day after tomorrow. Yes, my lord. Obliged.
May I please, your lordship? Lordship, item number 22 of today's list.
Yes.
In this matter was first, it was heard in court number 10 by Justice Mehdi. Here, we had completed our part. The learned AG also had completed their part. It was the respondent number 4, 5 who was supposed to. The file may be looked into it. Order dated 23/11/23. Then on first, the learned AG completed his argument.
Entire day was consumed, my lord.
Mr. R.J. Das, you are for the petitioner.
I am for the petitioner.
Learned counsel for the learned counsel for the petitioner, and Mr. S. Bora,
For GMD, my lord. Yes.
learned standing counsel. For GMDA.
GMD, my lord.
One,
Okay,
two,
GMDA. For the state respondents have referred to the orders dated 21/11/2023.
yes, 21/11/23 and 23/11, all these orders,
And 112.
23/11/2023
and 1/12/20.
112.
and 1/12/2023 to submit that the writ petition has been heard at length by coordinate bench of this court. Put in bracket SK Mehdi, Justice. Where the petitioner side and the state respondent side
And the GMD from the respondent, my lord.
have concluded their arguments by submitting show from the learned counsel for the parties have submitted that further submitted that matter be listed. Matter is to be listed before the state coordinate bench. In view of the above submission from the registry to verify the same and list the case before the appropriate bench.
Deeply obliged.
Please, your lordship, I'd like to mention item number 31, lordship. I am preparing for adjournment, lordship. My senior is out of station, your lordship, due to some personal reason.
31.
31, lordship. I am for
Okay.
petitioner,
You are for the petitioner.
lordship.
You have informed the other side.
You know, he is on leave, which reflect on the cause list.
No, you have informed the other sides.
No, lord,
Huh?
not yet.
Then yesterday same issue cropped up. You wait or otherwise inform.
May I please, your lordship? Lordship, I beg to mention a matter of urgent listing for tomorrow. Urgency is we have been served with an eviction notice that might be effected tomorrow or day after tomorrow.
Eviction notice.
Yes, we have been served with an eviction notice so that we've been given 15 days time period. So
New
that
writ petition.
New writ petition for tomorrow, lordship. Much obliged.
May it please your lordships. Your lordships, in item number 13, we have filed an additional affidavit that may kindly be called for.
Okay.
May I please, your lord. Similar in item number 40, my lord. Supplementary list, my lord. I have filed a caveat petition, my lord, today, my lord. That
40.
40, my lord.
You want,
I
you
filed
have filed?
caveat, my lord.
Yeah, okay.
Obliged.
May it please your lordship. Lordship, with your permission, I'd like to mention item number 39. Lordship, it's the hearing list. It'll take some time. So praying for an adjournment, we've informed the other side.
You are part of it.
Yes, sir.
Respondent.
Yes, sir.
Okay. MS
G. Goswami.
D. Goswami. Learned counsel for the petitioner has sought listing of the case when?
Lordship,
After vacation?
after vacation.
After the ensuing winter vacation.
Lordship, can it be listed on a Tuesday or a Thursday because there's an outstation council engaged in the matter?
Okay, Mr. KP Pathak. You are for,
Respond number 8. Your Lordship.
learned counsel for the respondent number 8. Who is present, has no objection to say prayer. Mr. S. Burwa, junior government advocate for the state respondents, is also present. Prayer is allowed, release the case. Release the case. January is full, otherwise. 1st of February, Thursday,
Very well.
Oblige, your lordship.
release the case, 1st of February.
Oblige.
Daily list for motion, item number 1.
May I please your lordship? My lord, this is a case where, my lord, there is a gross misuse of official power and authority, my lord, by the ADC. On the last occasion, my lord, a direction was given to produce, my lord, certain records, my lord.
Yes, I think.
We have got the report. In fact, hearing has been convened for 3 days. On 2 days, necessary parties were not present. Apart from summoning, the hearing could not be complete.
Copy আছে নেকি? Copy আছে নেকি?
What kind of proceeding he has drawn up? There is no case number, no proceeding number.
Yes, I have gone through it.
There is nothing at all, my lord. Just because this private respondent is having an affinity with him, my lord, and he is interfering in the land matters, my lord. This is a land dispute, my lord, which should be referred to the civil court for adjudication, my lord. And my lord, he is misusing his authority and powers and thereby, my lord, causing all this disturbance, my lord, to the petitioner.
Lordship, may I be granted with an opportunity to file a detailed affidavit as regard the contention that has been made here? Notice may go, short date may be fixed. In the meantime, we will file our response.
At whose instance and under what provision the proceeding is drawn up, though it mentions at page 37 for demarcation. Who has asked for the demarcation? If any application for demarcation is submitted, then a case is to be registered.
My lord.
Demarcation case, I don't know, because this order sheet does not reflect anything, it is blank.
It doesn't reflect, yes. I have gone through, yes.
It's not. Heard Mr. G. Chaudhary, learned counsel for the petitioner, and Mr. S. Borua. Why personnel department?
Because we have made these, my lord, this respond number 3, my lord. And my lord, a party and there is allegation that, my lord, he is misusing, that is why, my lord. So that at some point of time, if the honorable court comes to that finding, my lord, some sort of directives can also be issued, my lord.
Further, we are not very interested in response number one.
Yes.
My lord, in fact, on the
One
last
and two.
occasion, my lord, the understanding was that, my lord, if these records which come is not, my lord, sufficient, my lord, to, it will be disposed of, my lord.
The case projected by the petitioner is that he is the owner and patadar of a plot of land measuring 1 katha, 5 lesses, comma, covered by tag number 472 and periodic patna number 3, comma, situated at village Bamun Suburi, Mauza, Bhairabpat, district Sunitpur. Within brackets, subject for sort, which after purchase by a registered sale deed dated 16/3/2019, comma, had been mutated in the name of the petitioner in the revenue records. The petitioner has alleged that a proceeding has been drawn up in the office by the office of the district magistrate Sunitpur between the petitioner and the respondent number 4 on the ground that there is an alleged dispute with respect to a road for ingress and egress of the respondent number 4. Full stop. Notices were issued by the office of the respondent number 2 to the petitioner to appear before the additional district magistrate from time to time. Full stop. It has been contended by drawing up the said proceeding, comma, the respondent number 3 has sought to demarcate the subject lot of the petitioner in order to carve out a road for ingress and egress of the respondent number 4. Also, it has been further contended that the petitioner has not been informed under what provisions of law the proceedings and at whose instance the proceedings have been drawn up, whereby the petitioners have been asked to appear before the respondent number, before the office of the respondent number 2 from time to time. Full stop. When the writ petition was listed previously on 4/10/2023, comma, the learned state council was asked to obtain preliminary instruction and to apprise the court as to whether any demarcation case has been registered, and if so, comma, the basis of registration of such demarcation case. The Lawrence State Council was also asked to apprise as to whether the respondent number 3 was involved in the matter in any manner. First up, Mr. Burwa, Lawrence, Senior Government Advocate, Assam, has placed a communication bearing number so and so dated 17/10/2023 of the district magistrate Sunitpur in reference to the order dated 4/10/2023. A and or orders it of the proceedings drawn up between the respondent number 4 and the petitioner is found annexed to the state communication. It does not, the orders does not reflect any does not reflect under what provisions of law the proceedings has been drawn up. It also does not reflect at whose instance the state proceedings has been drawn up. The report annexed to the a report annexed to the state communication has not thrown any light as regards the details of the proceedings so drawn up. As the contents of the communication dated so and so are not sufficient to take a view as regards the legality and validity of the proceedings so drawn up from a proceedings reference as normal. In the above view of the matter, let notice be issued to the respondents making the same. The notice is made returnable in 4 weeks. As Mr. Borua appeared accepted, 1 and 2, no formal notice. Extra copies.
We had served 3 copies, man.
The petitioner, we need 2 working days. The petitioner shall take steps for service of notice upon the respondent number 3 and the respondent number 4 by registered post utility within 2 working days, having regard to the projections made in the petition. It is provided that the further proceedings drawn up against between the petitioner and the respondent number 4 by the office of the respondent number 2 shall be kept in abeyance till the returnable date. The respondents shall file their responses on or before returnable date.
And if
Item number 2.
My lord, there are some mistakes in the draft. I may be allowed to withdraw it and file fresh.
You want to withdraw?
With limited file fresh.
Mr. H.
Moria.
Learned counsel for the petitioner has submitted that as there is some mistake inadvertent mistakes kept in in the repetition, the petitioner wants to withdraw the petition with the liberty to file a press. Mr. A. Bhattacharya, Learned Standing Counsel, Revenue for the respondent number one. Petitioners, one. And Mr. S. Burwal, Learned Senior Government Advocate Assam for the respondent number 2 and 3 are present. In view of the above submission made by Mr. Muriel, Learned Counsel for the petitioner, the petition is dismissed on withdrawal, with the liberty to file a press.
Okay.
Item number 3.
Please, Your Lordship. Lordship, this matter has come up today for correction of the cost title, Lordship. The respondent number 1 and yes, Lordship. There is application order 6, rule 17.
You have filed a petition for what?
Ritu, we have challenged a speaking order, Lordship, passed by the respondent number 3.
Speaking order?
Yes,
Okay,
Lordship.
what is the speaking order?
The speaking order was passed pursuant to a direction of this honorable court, Lordship.
Which page?
Speaking
In the-
order, Your Lordship will find at page 80, lecture 10. The dispute was regarding a plot of land. So that plot of land, Lordship, was initially in the map prepared by the NHIDCL for acquisition, for widening of the national highway. But subsequently, another map was prepared, Lordship, and the portion of my land was converted to unknown DUG numbers. Initially, we filed representation before the NHIDCL, but nothing was done. So we preferred a writ petition. That writ petition was disposed of in the motion stage, directing us to file a representation within 2 weeks, which we did. And thereafter, if such a representation was filed, the respondent authorities were directed to file a speaking order after carrying out proper spot verification and consulting the revenue records. They have done that, but what they have done is that on the one hand, they have said that as per the original revenue records, that 20 bighas of land belongs to me. But the same land, they have said that as per a spot verification data, that land belongs to the forest department also in the speaking order. Lordship will find that in page 82. So that is why we have come up before this court basically
to implead whom?
Implead, Lordship, the respondent number 1 was wrongly the principal secretary of the revenue department was wrongly shown as the principal secretary of the Karbi Anglong Autonomous Council. So that needs to be, Lordship, corrected, and the respondent number 5.
Mr. MP Chaudhary. Yes, anything? Impleading petition? Correct, this petition? Okay. Mr. MP Chaudhary. Learned Counsel for the petitioner. And Mr. Mr. R.K. Talwar? Yes. Okay, Mr. J. Sutia, Learned Standing Counsel, Karbi Anglong Autonomous Council. And Mr. R.K. Talukdar, Learned Standing Counsel,
NHIDCL.
NHIDCL. Any state council
Revenue.
required?
Revenue. That's the
Okay,
number 1.
Mr. S. Burwa, Learned Junior Government Advocate for the state respondents. SP is there.
SP. Respondent number
DFO is under KAC.
Case 1.
Okay. The applicant as the writ petitioner has preferred the connected writ petition, 6620/2023 to a sale and order dated 21/6/2023.
Yes, Lordship.
Passed by
Passed by the Joint Secretary to the Revenue Department. Competent
passed
authority.
by the Joint Secretary,
Respondent 3.
Revenue Department.
Yes, Lordship.
Page, where is the page in the petition?
In the IA or the Lordship, writ petition, your Lordship will find at page
7.
80.
Yes, Lordship, page 7, yes. Last
80. Joint Secretary, Department of Revenue and Competent Authority Land Acquisition. Joint Secretary, Department of Revenue, Karbi Anglong Autonomous Council, Roman and Competent Authority Land Acquisition, this is Kala. The instant interlocutory application has been preferred by the applicant with petitioner seeking amendment stroke correction in the cost title in the connected writ petition. Insofar as the particulars pertaining to the respondent number 1, party respondent number 1 and the party respondent number 5 in the array of respondents. Full stop. It has been averred that due to typographical errors, comma, the party respondent number, the details, particulars of the party respondent number 1 have been shown as quote, the state of Assam represented by the quote unquote paragraph 5 of Assam, represented by the principal secretary to the government of Assam, comma, Karbi Anglong Autonomous Council, comma, Dipu 782 460 Karbi Anglong Assam, unquote. Instead of quote, the state of Assam represented by the principal secretary to the government of Assam, comma, Revenue and Disaster Management Department, comma, Assam Secretariat, Dispur, comma, Guwahati 781006, unquote. Similarly, the particulars of the party respondent number 5 have been reflected as quote, paragraph 5 of the correct to 6 of the Ministry of Road Transport and Highways, represented by the General Manager, National Highways and Infrastructure Development Corporation Limited, NHIDCL, Dipu 782 460 Karbi Anglong Assam, comma, instead of the General Manager, comma, National Highways and Infrastructure Development Corporation Limited, NHIDCL, Dipu 786 460, comma, Karbi Anglong, comma, Assam, unquote. Full stop. It is submitted on behalf of the petitioner that the such corrections are required for effective adjudication of the connected writ petition. Full stop. The prayer for amendment stroke correction in the cost title in the corrected writ petition have not been objected to by the learned counsel appearing for the opposite parties. Full stop. I have gone through the affirmative statements and affirmative in this interlocutory application. And it appears that the mistakes crept in the connected petition appear to be inadvertent ones. Full stop. For effective adjudication of the issues involved in the connected litigation, comma, such amendments to correction as regards the party respondent number 5 and the party respondent number 1 and 5 appear necessary. Accordingly, the instant interlocutory application stands allowed office to cause necessary correction in the cause title of the connected in petition insofar as the party respondent number 1 and the party respondent number 5 are concerned in the manner indicated above. Also, for facilitating such amendment correction, comma, the learned counsel for the petitioner shall file an amended cross title in terms of the notification dated so and so by tomorrow. Full stop. When do you want?
No, after vacation, let it come up.
Okay. Thereafter,
For motion.
release the a connected repetition immediately after the ensuing winter vacation in the motion call.
Item number 4.
Lordship, similar order in item number 4 will also.
Party number 1 and 5.
Yes, party number 1 and 5, only the
Same.
petitioner is different, applicant is different.
Okay. Same. I too.
Highly obliged.
Item numbers 5 and 6.
Mr. Das, it would require some time. Let the motion be over, then we'll take up. There are not many motions.
Item number 7.
Yes, Mr.
May I please, your lordship? Lordship, this is the second round of leave.
Second round,
Second round, lordship.
Why?
Earlier, lordship, the petitioners were the respondent, lordship.
who are the petitioner? How many?
Two, lordship.
Two.
Lordship, may kindly come to the order, lordship, which was passed in the earlier
Order.
petition. Page number-
Earlier. Okay. Which one?
Page number 61, lordship.
61. Who preferred?
The respondent hearing, lordship.
Huh?
The respondent of the present writ petitioner.
Okay.
Earlier, they were the writ petitioners, lordship.
So
61.
they are on the date of Abul Fazal Pradhani, Nabir, Rosina Begum, Afruja Begum, Anwar.
They are the respondents now, lordship. Page number 61.
Rosina, Afruja, Anwar, Rofikul, Ranjina, Anarkuli, Bobita, Sofiul Islam Patani, Sofiul Islam,
Respondent number 15.
Mofida Begum, Fateh Ali Pradhani, Khairul Islam. And you were responding or what?
Respondent, lordship. 8 and 9.
Okay, read page 60.
Page number 61, lordship. Initially, this writ petition was filed by 3 numbers of petitioner. However, during the pendency, the writ petitioner number 1 had passed away and has been substituted by his legal heirs. The grievances is broadly against the action of the revenue authorities in inserting the names of the respondent number 7 and 8.
That is you.
That is me, lordship. We, 2 petitioners. In the records of right pertaining to a plot of land measuring 2 bighas 3 kata 9 lesser, covered by dag number so and so, pattern number so and so, at village so and so. It is not in dispute that petitioner and the private respondent number 7 and 8 are the legal heirs of Naibur Rahman Pradhani. It is the case of the petitioners that as per the family arrangement, the present plot of land was allotted to the petitioners and the respondent number 7 and 8 were allotted another plot. Accordingly, in the records of the right, it was the names of the petitioners which found place. However, it appears that behind the back of the petitioners, the respondent number 7 and 8 had applied for inclusion of their names, and the same has been done. The petitioners allege that the aforesaid correction has been done without giving any opportunity to the petitioners, and on the aforesaid ground, the writ petition has been filed. MS Chaudhary, the learned counsel for the petitioners, submits that the petitioners would be satisfied if the matter is remanded back through the concerned authority, namely Settlement Officer Dhupri and Kokrajhar District, to reconsider by hearing all the affected parties. Shri So-and-so learned counsel for the respondent number 7 and 8, however, disputes the projection made by the petitioners and submits that they being the legal heirs of so-and-so are at par and their names are rightly reflected in the records of the right of the plot of land in question. The learned counsel, however, has not opposed to the proposition that a hearing may be afforded to all the affected parties before including their names in the records of right. Sri so-and-so learned estate council submits that such a direction may be issued, which will redress the grievances of the petitioners. In view of the aforesaid facts and circumstances and broad consensus
Arrived at the bar.
arrived at the bar, the exercise for inclusion of the names of the respondent number 7 and 8 of the Jamabandi in the Jamabandi of the plot of land in question be done by the competent authorities indicated above by affording the affected parties, that is the petitioners and the respondent number 7 and 8, an opportunity of hearing. The parties would be at liberty to submit any written statement as well as documents to substantiate their grievance, their respective claims. The aforesaid exercise shall be done within a period of 3 months. Thereafter, Lordship, the respondent number 11, Lordship, submitted one petition before the assistant settlement officer. Lordship may kindly come to page number 66. This is the order passed by the assistant settlement officer pursuant to the order passed by this honorable court.
Let us read.
Miscase number 34/2023. The miscase is put up today. Seen the case record, land record, LM report, land relevant documents and direction of the Honorable Guwahati High Court in respect of WPC number so and so dated 9/1/2023, Lordship. This is a typographic error. The case in brief is that a plot of land measuring so and so under village so and so recorded in the name of Nabir Rahman Pradhani, son of so and so.
Nabir Rahman Pradhani.
Nabir Rahman Pradhani.
Who is he?
He is the father of the petitioner as well as the respondent's, Lordship. The
And
land,
who is Abul Fazal Pradhani?
the son of the
Son of Nabir.
Nobel.
Nabir.
Yes, Lordship.
So, these two petitioners,
Are the son of Nabir.
son and daughter
Son and daughter, Lordship.
of Nabir Rahman Pradhani.
Yes, Lordship.
Then you say that this Abul Fazal Pradhani was also a son of Nabir Pradhani.
Yes,
Nabir
Rahman.
Rahman Pradhani.
Yes, Lordship.
And this respondent number 8, 9, 10, 11, 12,
13,
13,
14,
14, 15, 16. They are sons and daughters of
17 also.
17 also, sons and daughters of Abul Fazal Pradhani.
Yes, Lordship. And
Then another two sons of Nabir Rahman is
18 and 19.
18 and 19.
19.
So basically it is 4 brothers, 1 sister,
Yes, Lordship.
right?
Yes.
Okay, let us read page 66. 66. Second paragraph.
The case in brief is that a plot of land measuring so and so under revenue village so and so, circle so and so, was originally recorded in the name of Nabir Rahman Pradhani, son of Khairuddin Pradhani. Further, the name of Abul Fazal Pradhani, son of Nabir Rahman Pradhani, and 2 others recorded in ROR by order of ASO dated 29/8/2019. Again, the name of second party.
This
named-
Nabir, Abul Fazal Pradhani and 2 others mean the respondents.
Yes, Lordship, the respondents.
ROR means record of rights.
Records of rights, Lordship.
Okay, 90. Okay.
Again, the name of the second party, namely Fazlur Rahman Pradhani and Nurima Khatun, that is the petitioner's, Lordship. Both are son and daughter of late Nabir Rahman Pradhani were inserted in the records of right by way of inheritance.
So this is an addition or replacement?
No, addition, Lordship.
Addition.
Addition.
So initially 3,
3,
then later on added
2.
the other 2.
Yes, Lordship.
That is the petitioners.
Yes, Lordship.
Okay.
By the order of ASO dated 26/6/2019 and 10/8/2021 respectively. First party, namely Rafiqul Islam Pradhani, son of Abul Fazal Pradhani, prayed for correction of land record as per the Honorable Guwahati High Court.
Correction in what sense? That you
Correction.
delete the name of these two petitioners.
Delete the name of these two petitioners
Okay.
by referring the order of the Honorable High Court. As
Okay.
per the Honorable Guwahati High Court, case number WBC number so and so, dated 19/1/2023. Hence this miscase. Notice is served to the parties, asked them to submit land relevant documents along with NOK certificate. Sufficient time and opportunity given to the parties to submit claim objection in favor of their prayer. Verified the record. It is seen from the land record that the name of both the party inserted in place of their deceased father come Pattadar in the records ROR. By verifying NOK certificate and other documents, it is seen that both parties are legal heirs of late Nobir Rahman Pradhani. Hence, both of them have legal right to insert their name in the ROR by way of inheritance. Heard learned advocate of the parties and recorded their arguments. First party could not submit any NOC agreement given by the second party in favor of them for correction of land record. Second party submitted NOC, NOK lordship, typographical error, NOK certificate and other documents which establish that both the parties are legal heirs of deceased Pattadar, that is Nobir Rahman Pradhani. By verifying the land record, it is found that mutation in favor of both the first party and second party were done in ROR in the year 2019, except Pattadar at serial number 8. That is about 4 years ago. Hence, the name of the second party could not be cancelled as per the rule 52 and 53 of the ALRR. In view of the above, LM is directed not to correct the land record. That is, the land record of the scheduled land remains unchanged.
Land revenue regulation.
The
Okay.
prayer petition of the first party is rejected.
That was in your favor.
That is in my favor. Now, Lordship, thereafter, what has happened, Lordship? By referring the Honorable Court's order, the respondent herein submitted another petition before the Additional Deputy Commissioner.
That order was passed when?
Lordship,
19/8/2022.
yes, Lordship.
Okay.
Lordship may kindly come to page number 73.
Three. Yes.
Already, Lordship, in the meantime, settlement officer has passed the order pursuant to the Honorable High Court. Now, this is the another petition filed by the respondent before the Additional Deputy Commissioner. 19/10/2023. The first party, Rafiqul Islam Pradhani, representing his father.
Rafiqul Islam Pradhani, he was a party?
Yes, Lordship. Respondent number 9. The son of Abul Fazal.
Abul Fazal.
Yes, Lordship.
Okay.
Rafiqul Islam Pradhani, representing his late father Abul Fazal Pradhani, present along with his uncles Khairul Islam Pradhani, Fateh Ali Pradhani, and their learned advocate. Second party Fazlur Rahman Pradhani and Nurima Khatun also present along with their learned advocate. First party represented by the learned advocate stated that his client, who are the legal heir of late so and so, have got the land measuring so and so, that number so and so, revenue village under Mankasar Circle of South Salmara, Mankasar district as inherited property from their late father, grandfather through right of inheritance. He further stated that the aforementioned plot of land was the part share of property which his clients inherited after the property was informally divided among the next of kin of late Nobir Rahman Pradhani, and that his clients are absolute owner of the land and are occupying it. Whereas the second party represented by their learned advocate stated that his clients, namely Fazlur Rahman Pradhani and Nurima Khatun, are also legal heirs of late Nobir Rahman Pradhani. As such, through right of inheritance, has right over the aforementioned property, and thus they had applied for mutation of their names in the property and have got it done through proportional. The advocate of the first party objected to this claim and states that while dividing the property of late Nobir Rahman Pradhani, the aforementioned property was given to his clients, though through informal agreement. As such, second party have breached this informal agreement and quietly, without knowledge of the first party, got their names inserted into and land records of the aforementioned property against which his clients had approached the Honorable Guwahati High Court for justice, and the Honorable Guwahati High Court in its judgment dated 4/1/2023 in connection with WBC number so and so ordered the ASO Mankasar Revenue Circle the exercise for inclusion of the names of respondent number 7 and 8 in the Jamabandi of the plot of land in question to be redone by the competent authority indicating above, affording the affected parties, that is the petitioners and respondent number 7 and 8, an opportunity of hearing. Further, the learned advocates have stated that while this case was pending running at the office of so-and-so, Mankasar Circle, Mankasar Revenue Circle, the names of many more legal heirs of late Nobir Rahman Pradhani was inserted into, and the land records of the.
What is he is mentioning here? Many more legal heirs?
My lord, in the meantime, what has happened, lordship? Three other brothers were also there,
Apart from this,
apart from this. They have also filed petition for mutation, and accordingly their name also got inserted.
who inserted? Settlement officer.
Settlement officer,
Settlement officer.
settlement.
Apart from these 4 brothers and 1 sister,
Yes, lordship. I have given the,
other names are also inserted.
yes, lordship.
Who? Who are they?
Lordship, may kindly come to page number 12.
Where? Nobir Rahman has how many children?
Page number 11, lordship.
His number is. Oh, 4 more.
Yes, lordship. Total lordship 9.
Fazlur Rahman.
Total 9. Out of 9
One minute,
lordship, 3
Yeah,
expired.
it is difficult for me to understand. Fazlur, who are the petitioners?
Petitioner is lordship here, who is at serial number 1,
Ah.
lordship, Fazlur Rahman Pradhani.
These 2 has other of the petitioner have 9 children,
Yes, lordship.
8 son and 1 daughter,
Yes, lordship.
including the petitioner. And out of 9 children, 2 has already expired. But in place of the sibling of the petitioner was to Abul Fazl, Habibur Rahman, Nurima expired. Yes.
Page number 75, lordship. Second paragraph. Further, the learned advocate have stated that while this case was so-and-so, more legal heirs of so-and-so was inserted into the land records of the aforementioned property, which is in gross violation of the order given by the Honorable Guwahati High Court judgment dated. Having heard both the parties and after studying the judgment of the Honorable Guwahati High Court in connection with WPC number so-and-so, the undersigned comes to this conclusion that the ASO Mankasur Revenue Circle is ordered to cancel the mutation done in favor of anyone except the second party.
Right. Then next.
Secondly, the second party being the legal heirs of late Nobir Rahman Pradhani may approach the ASO CO Mankasur Revenue Circle for a fresh hearing regarding mutation in their name, where the ASO CO Mankasur Revenue Circle will follow the process and call for hearing of both the parties before taking any decision.
What wrong?
My submission is that, lordship.
These other siblings,
Yes.
nine. Nobir Rahman had 9 sons and daughters.
Yes.
And contesting parties in the petition were 5.
Yes, sir.
Right?
Yes.
Then 2 on one side, that is the petitioners, 3 on the other side.
Yes, sir.
So matter was directed to be considered by the assistant settlement officer.
Yes.
After hearing the parties, right?
Yes, sir.
First party and second party,
Yes, sir.
and redone by affording the affected parties, that
Yes.
is the petitioners and the respondent number 7 and 8,
Yes, sir.
page 62.
Yes, sir.
But in the meantime, while passing this order, perhaps assistant settlement officer has gone beyond the High Court order. He has included the other sisters, daughters of Nobir Rahman Pradhani. So the deputy commissioner has the power,
Yes, sir.
has the power under Assam Land and Revenue Regulation. If you come to, if he sees something is wrong, He has also so much of power
Yes, Lordship.
other than under 151.
Yes, Lordship, that is there.
For such orders thereon, as it or he thinks fit.
Yes, Lordship.
He has he directed deletion of all these other inclusion. And once again to hear the matter afresh between the petitioner on one side and the other three brothers on the other side. Of course, one brother had expired. His sons and daughters are to be heard. So what wrong?
My lord, pursuant to the honorable court's order, that exercise was already carried out by the assistant settlement officer.
Right, but where is that the other inclusion? Tell me.
But Lordship.
He
if
has
we go
found
by-
wrong.
But Lordship, if we go by
So
the.
are you agreeing with that inclusion of 4?
No, Lordship.
Huh?
No.
Then we'll observe that. This
They are
inclusion
named
of
every-
additional 4 in the same pata and dag is permitted. Petitioner is agreed by that.
We are not aggrieved by the exclusion or by the deletion of the other names which were subsequently
he has not-
inserted into.
We
We are not aggrieved, Lordship.
One part, you cannot save one part and save other part. I will add, you cannot pick and choose, Mr. Counsel, that this order has 2 parts. I'll pick this one, I'll throw this one.
My only submission,
See,
Yes,
the assistant settlement officer, while passing the order pursuant to the disposal of the writ petition, he has done correctly.
Yes.
To that extent, that no correction is required, all are entitled by way of inheritance. 5.
five, yes, Lordship.
And affected parties, High Court said, affected party, that the 3 on one side and respond numbers 7 and 8 on the other side. They are to be heard
Yes, Lordship.
with regard to the plot of land. This assistant settlement officer, I think he received other applications from other 4 brothers. He also included their names in the same plot of land. It became 9 instead of 5. Right?
Yes, Lord.
Deputy Commissioner has a suo motu power also,
Yes,
apart
sir.
from the power. And they had this other sides, they had also complained perhaps that, see, the fight was between, contest was between we 3 and these 2 on the other side. Now, see, 4 more have been included by the assistant settlement officer. This is not correct. Show me the petition then.
Now,
Filed by this other sides, your contesting sides. Because if they are objecting to it, that inclusion of 4 other brothers, then Deputy Commissioner is correct in the sense that yes, this is not correct in terms of the direction of the High Court.
but Lordship, I am aggrieved.
You are aggrieved to part. Show me the petition.
May I submit, Lordship? I am not aggrieved by the. order
Your
of the-
name has been kept, right?
Yes, Lordship.
But after deletion, that both the parties, these 2 petitioner and the 3 brothers on the other side be heard again. Because this order has suffered. What is the application, exact application of this, your other side?
I have not annexed.
They might have prayed that, see, while the contest between we 3 on one side and these 2 on the other side, this assistant settlement officer has incorporated 4 more names. Have you understood?
Yes, Lordship.
If that is the case, then they are entitled to file a application. And Deputy Commissioner is justified to pass the order
Yes, Lordship.
because he proceeded wrongly.
But Lordship,
Taking
after this order,
cue from the direction of the High Court, he should not have included the other 4 in the same plot of land.
yes, Lordship.
The option for the other 4 would have been different. They should have pursued different remedy.
Yes.
They could not take shelter of the High Court direction. Those 4,
Yes.
not
Not the
3
present
plus 2,
petitioners. Yes,
not
Lordship.
3 plus 2. They have come through the back door with the help of the assistant settlement officer. So Deputy Commissioner has correctly read the High Court order
Yes, Lordship.
and he said, don't include these four. Yes, these two petitioners,
Hmm.
the second party,
Yeah.
they be there.
That
They
is
be there, but you hear the matter again.
Yes, Lordship. But Lordship, our
Show me the
grievances,
petition.
our grievances is that Lordship, before hearing Lordship, this assistant settlement officer has deleted our name also. That is the case, Lordship.
No. How?
That has been done, Lordship. He has deleted the name of the present petitioners also. Even Lordship, let there be a fresh hearing. I'm not aggrieved by that, Lordship. I will participate. We will participate, Lordship.
Yes, you participate.
Yes, Lordship. We will participate. Let there be a direction not to delete our name, Lordship. The name of the two petitioners, which is very much there in the order of the Deputy Commissioner also, not to delete the name of the second
Come to
party.
the Assistant Settlement Officer's order.
That is in our favor, Lordship.
Then why you are submitting differently?
Assistant
Yes.
Settlement Officer order is in our favor.
Right.
Thereafter, the order passed by the Additional Deputy Commissioner.
Yes.
Thereafter, Lordship,
Yes.
to hear the matter afresh,
Afresh.
meaning thereby the order which was passed by the Assistant Settlement Officer has gone.
Has gone, but he has observed. Assistant Settlement Officer, Mankasar Revenue, he is also Circle Officer.
Yes, Lordship.
Mankasar Revenue Circle is ordered to cancel the mutation done. Where is the original order? Let us see the handwritten one. Is ordered to cancel the mutation done in favor of the anyone, comma, except for the first party. Okay.
We are agreed by this only, Lordship. Let there be a fresh hearing. We are not aggrieved. But Lordship, before hearing deletion of our name, Lordship, that too, Lordship, by referring the order of the Honorable High Court.
Come to page 62.
My Lord.
You start from page 61, last line.
In view of the aforesaid facts and circumstances, at broad consensus arrived at birth, the exercise
This
for
one is important. The exercise for inclusion of the names of the respondent number 7 and 8 in the Jamabandi of the plot in question be redone. The exercise for inclusion of the names of the respondent number 7 and 8 in the Jamabandi of the plot in question be redone by the competent authority indicated above by affording the affected parties, the petitioner and the respondent number 7 and 8, an opportunity of hearing. So this word, the exercise for inclusion of the names of the respondent number 7 and 8 in the Jamabandi of the plot of land in question be redone. So
my name has to be struck up.
from the very beginning. Have you understood now? That is why I have read it slowly.
Yes.
So this court had observed that
Has
this
to be redone.
inclusion of name of the two petitioners in the Jamabandi be redone, meaning thereby as if your name was not there in the Jamabandi. So I cannot sit over this judgment. You also cannot. Deputy Commissioner has rightly ordered.
But the same exercise has been done twice, Lordship, once by the Assistant Settlement Officer and subsequently by
He had done the exercise.
even Lordship,
He had done the exercise, but he had done it as if for not inclusion. He said retain.
Yes, Lordship.
He said retain. Your
I
names
got
are
it,
there in the Jamabandi, retain their name. Then Deputy Commissioner has clarified that remove all the names, except the petitioners in the earlier writ petition, and inclusion of the names of these two petitioners be done first. He has correctly understood page 62. This statement.
Yes, Lordship. But at the same
And I am also of the same view.
now, Lordship, I am also in this.
I am also of the same view.
Here in this case, Lordship, the respondents, Lordship, first they have submitted the order of the Honorable High Court before the Assistant Settlement Officer. Hearing was done. Everybody was heard. Opportunities were given. And Lordship, when order goes against, has gone against him, then he filed another.
He is
representation,
at least, if we go by minute interpretation, this other side has a cause of grievance, yes.
They have
You
not
should
challenged
have,
the order of the
as
Assistant
if their
Settlement
names were
Officer.
not there, you should have done the hearing for inclusion of the name of the petitioners. And second part, why you are incorporating 4 other names in the meantime,
We are also agreed by that. Lordship.
right?
Yes.
So,
That
to
cannot
that part of the Deputy Commissioner, that remove all the names. You are not aggrieved. You are aggrieved by also by that 4 brothers plus you two.
Yes,
Deputy Commissioner has directed for deletion, cancellation,
yes, Lordship.
right?
Yes.
Out of these 4, 6, about 4 you have no objection.
No.
Okay, remove them.
Yes, remove them.
You are aggrieved by deletion of your name,
Yes.
right? But for you, opportunity has been provided by the Deputy Commissioner. You hear these 2 already. Is it not?
Yes, yes, Lordship. That is their Lordship. The second,
Second part
second part,
is
Lordship.
you hear these 2 petitioners only. And if you go back to page 62, the exercise for inclusion of the names.
To be redone, meaning thereby my name has to be.
So if you want to say something, then you have to assail this order. That this exercise of for inclusion.
My lord.
Am I clear now?
Yes,
Are you clear?
yes, Lordship.
I don't think we need interference.
Yes.
Yes, it is very hard to understand. But ultimately, this line is 62.
At the same time, Lordship, one thing is very much clear, Lordship, the respondent, private respondents, Lordship, first they approached one authority and then, Lordship, they have not challenged the order passed by the ASO. They simply filed another representation before the additional deputy commissioners.
That is why I have referred to pay.
Yes, Lordship. The order of the deputy
Provision of
commissioner is correct.
151, Deputy Commissioner has full power.
Here, Lordship, the deputy
As,
commissioner has not
as if
exercised
he is
suo
an
motu power.
appellate, otherwise suo motu power.
But he has not exercised suo motu power.
Source is available. Power,
The power is there, Lordship. I'm not.
source is available under the law to him. And source can be relatable, it can be treated as an appeal also. If you go by section 147. See, 147,
Yes.
appeal shall lie
Revenue.
under this regulation to the Deputy Commissioner from orders passed by subdivisional officer and assistant commissioner or extra assistant commissioner to the settlement and settlement officer. If settlement operation is not there, then it is Deputy Commission. It will be there. I think 133 perhaps. So otherwise it is, the power is available to him under section 151. So moto. So even somebody has drawn attention to him, then he can exercise. Any officer subordinate to him.
151.
So I don't think it is a case for exercising 226. Because the earlier round, the court has made it clear.
Yes, Lordship, we will participate there. Lordship. And circle officer is free to pass order, Lordship, after hearing us.
Should we pass a detailed order or what? By interpreting?
No,
In
Lordship,
fact, things are clear because
There is no, we'll simply say, there is no cause to interfere in this case, but petitioner should be given every opportunity
yes,
to
Lordship,
participate.
of presenting his case
before the assistant.
before the
settlement officer.
assistant settlement officer in terms of the directions given by the deputy
Yes,
commissioner.
sir.
Yes, that would be clear. Yes,
I think that will.
yes, yes.
Yes, yes. Sir.
heard Mr. M. Ahmed, learned counsel for the petitioner. And Mr. A. Bhattacharya, learned standing counsel revenue for respondent number 1 and 2. Mr. S. Borua, learned junior government advocate Assam for the respondent number 3 to 7. Full stop. The two petitioners have sought to assail. By filing this petition, the two petitioners have sought to assail an order dated 19/10/2023. Green bracket. Annex Roman 8. Passed by the additional deputy commissioner, South Salmara Mankasar, Hatsing Mari. Full stop. It appears apposite to state that from the pleadings in the writ petition, it has the subject matter of dispute. No, sorry, the dispute is relatable, is with regard to a plot of land and DAG number 165, Patta number 160. Oh, sorry. DAG number 165, Patta number 64. Situate at village Hatsing Mari, Mankasar Revenue Circle, District South Salmara, Mankasar. Subject. Full stop. The erstwhile owner and pattadar of the subject plot was one Nobir Rahman Pradhani.
Yes, sir.
Full stop. The dispute, sorry, full stop. The two petitioners hearing. 1 minute. The Nobir Rahman Pradhani had 8 sons and 1 daughter.
Yes, sir.
Full stop. The dispute originally arose, dispute regarding the right to inherit the subject plot originally arose between the two petitioners herein being a son and the only daughter of Nobir Rahman Pradhani on one side and 3 of their brothers, namely TIZ. One, Abul Fajol Pradhani, since deceased. Bracket. Two, Fote Ali Pradhani, 18, respond number 18, naam to side. And three, Khairul Islam Pradhani. Full stop. The other four siblings are on the other side. The other four siblings of the two contesting sides were not originally part of the contest. Right?
Yes.
Fair enough. The original dispute as regards mutation in respect of the plot of land and reflection of the names of the two contesting sides in the records of right. Full stop. It appears, it transpires that the names of the on one hand, one side first party or second party. Names of the first party were mutated. Names of the first party, that is one, Abul Fazl Pradhani, Roman 2, Fote Ali Pradhani, and 3, Khairul Islam Pradhani, stood mutated at first point of time. Full stop. Later on, the names of the second party that is Fazlur Rahman Pradhani, within bracket the petition number 1, and 2, Nurima Khatun, the petition number 2. Stood mutated in respect of the subject plot. সেই তিনজন আছিল ন ডেটটো দিব অন 29/8/2019 প্ৰথম তিনজন stood mutated on
Page number 69, Lord.
26/10/2019 and 10/8/2021 respectively. It was after inclusion of the names of the second party in the records of right, Jamabandi, within bracket records of right, the dispute started to erode, and the members of the second party as writ petitioners preferred a writ petition. WBC number 6434 stroke 2021. It is pertinent to mention that Abul Fazal Pradhani expired in the meantime and his legal heirs were substituted sorry, who was the read petition number 1, expired in the meantime, and his legal heirs, and his name was substituted by his legal heirs in the said read petition as paragraph page 50 it'll say 1.1 can say another. The said legal heirs of Abul Fazal Pradhani, late Abul Fazal Pradhani, have been implemented as party respondent number 82 17 in the present repetition. Para. The Learned Council the repetition was repetition, WPC number 6434/2021 came up for consideration on 4/1/2023, and the said repetition was disposed of by an order of event date, after hearing the Learned Council for all the sites. Full stop. The two petitioners hearing were implemented in the said petition as party response number 7 and party response number 8, and they were also heard. Full stop. The operative part of the order dated 4/1/2023 reads as under case 61 of A2A. It was in pursuance of the direction made in the order dated 4/1/2023 Supra, the Assistant Settlement Officer heard the parties in connection with mismutation case number 34/2023, and after hearing the parties and after verifying the land records, he disposed of the case by an order dated 19/8/2023 by observing that members of the first party as well as the second party were legal heirs of late Nabiur Rahman Pradhani, and hence there was no requirement to correct the land records, and the land records would remain unchanged. Full stop. In the process, the Assistant Settlement Officer rejected the prayer petition of the second party, seeking deletion of the names of the members of the first party, i.e. the two petitioners having. agreed by the rejection of their petition seeking deletion of the names of the two petitioners herein. They preferred an application before the additional deputy commissioner, South Salmara Mankasar, seeking correction in the land records regard to the subject law. Full stop. Both the parties were heard by the additional Deputy Commissioner South Salmara Mankasar Hatsingmari. Full stop. A finding was recorded in the impugn order to the effect that when the proceedings of the mutation case was pending at the office of the Assistant Settlement Officer, Stroke Circle Officer, Mankasar Revenue Circle, the names of the other legal heirs of late Nobir Rahman Pradhani came to be inserted in the land records pertaining to the subject lot. And such insertion was found to be in violation of the direction made in the order dated 4/1/2023, passed in WPC number 6434/2021. The application preferred by the members of the second party was disposed of by the additional Deputy Commissioner so-and-so by an order dated 19/10/2023. The operative part of the said order dated so-and-so reads as under page 75, B to B. It is agreed by that part of the aforesaid order dated so-and-so, order dated 19/10/2023, the petitioners, the two petitioners have prepared the petition with a grievance that the additional Deputy Commissioner, District Commissioner, South Salmara Mankasar Hatsingmari, apart from ordering deletion of the newly inserted names in the land records pertaining to the subject lot, also ordered deletion of the names of the two petitioners from the records pertaining to the subject lot, and has ordered fresh hearing. The such contention does not appear to have any substance in view of the direction already made by this court in the order dated 4/1/2023, wherein it had observed that the exercise for inclusion of the names of the two petitioners in the Jamabandi within bracket records of right of the subject lot in question is to be redone by the competent authority, that is the Assistant Settlement Officer, by affording the affected parties, that is the first members, that is the first party, within bracket the petitioner's hearing, and the second party, comma, with a bracket, the respondent number. Respondent number 6 to
8-2, Lordship.
17.
8-2.
6 to
8, Lordship.
19.
19.
6 to 19.
8, Lordship. 8 to 19. Lordship.
8 to 19.
8 to 19.
An opportunity of hearing. Full stop. The court had also observed that the parties would be at liberty to submit any written statement as well as documents to substantiate their respective claims. Thus, it is clear that the competent authority was directed to undertake the exercise for inclusion of the names of the two petitioners in the Jamabandi or the subject plot as if their names were not included in the revenue records of the subject relating to the subject plot. So, in such view of the matter, the writ petition is found not merited. Full stop. And accordingly, the same is not entertained. Full stop. The Assistant Settlement Officer shall proceed with the matter of inclusion of names of the two petitioners in the Jamabandi record of rights relating to subject plot by affording opportunities of hearing to all the two contesting sides, and also giving liberties to the contesting sides to submit a written statement as well as documents, documents to substantiate their respective claims. The entire exercise shall be completed as expeditiously as possible, preferably within a period of 2 months from today.
My only
From the date of submission of a copy of this order by the petitioners and the office of the Assistant Settlement Officer, so and so, to Silo.
and
I don't think this is.
yes, Lordship. And till the correction of the land record, Lordship, both the petitioners and respondents herein, Lordship, they shall not proceed to alienate the property.
Huh?
The respondent authorities may be directed not to issue any sale permission, Lordship, in respect of the particular.
No,
plot.
that is not required. We found this petition not
Yes,
merited.
I
Other in view of the above, as the repetition is not found merited, notice, issuance of notice to the other respondents is not found necessary.
within 2 months. Lordship.
2 months.
Highly applies.
Item number 8.
That is a lot. But here we have filed the respondent number 7 is a society. It was allotted a plot of land measuring 30 bighas.
Respondent number 7.
Is a society, registered society,
Hmm.
and we are the members of that society. And the government of Assam earlier in 1996 gave a proposal for settlement of 30 acres of land for the construction of houses of the members of the society. And the members have paid premium for the this 30 acres of land. And after that, they have entrusted for construction of separately buildings to the by engaging a contractor. But when the Act of 2008, that is Guwahati Water Bodies Preservation and Conservation Act of 2008 came in, no permission was granted, and subsequently some dispute also arose between the,
Oh, that one.
yes, that one, my lord. And if you're on a kindly take up page 300.
300.
The entire thing is clear from this certificate issued by the Samiti. May I read, my lord?
Okay, yes.
Yes, this is to certify that the Purbanchal Griha Nirman Unnayan Samiti, Hangrabari, Guwahati, so and so, registered under the Register of Societies, was settled with a plot of land measuring 30 acres by patta number so and so, dag number so and so, New Village, Hangrabari. Out of the above 30 acres of plot of land, the society had by deed of declaration stated 26/10/2006 and 9/10/2006 conveyed an area of total 10 acres of land out of 30 acres among 33 of its following members as their share of land. The details of the same are given below. Out of the 33 members, the names of the 12 members and area land allotted to them as per individual registered deed of declarations dated 26/10/2006 are shown below. The name of members, 12 members are given here. Then out of the total 33 numbers of members, the names of balance 21 members were area allotted to them as per individual registered deed of declarations dated 9/10/2006 are shown below. The next page, my lord. The names up to 21 members are given. Total land 10 acres. So out of 30 acres, 10
This is Buddha boat, that is 1 to 12
one
plus 1 to 21 means total 10 acres.
total 10 acres, 33 members. And this 12,
Okay,
first 12,
33 members, 10 acres.
yes.
Yes.
Now this first 12 out of 12 members, 10 of them had preferred its title suit before the civil judge, number one, and an injunction has been granted against this society and its present executive officials of the society. That is also pending. And when they came to know about this acquisition of land, because an order was passed when this Water Bodies Act came into force, the society filed a writ petition before this court, as well as the builder who took the position from the society as well as from the members of they also filed a writ petition to remove this area from the Water Bodies purview of this Water Bodies Act. So during the hearing, this court, the Landed Council for the state informed that this land will be acquired. Now this land in question, entire 30 acres of land, stands in the name of the Samiti, that is the society. But these 33 members were handed over position. The Lordship will see page 301.
So by virtue of this registered deed of declaration, according to you, you are persons interested.
Yes. And now,
Sum and substance, you are persons interested.
yes,
In the case of acquisition,
yes, my lord.
You-
Only thing we need that notices to us to be given, and we must be given an opportunity to represent our case. The Lordship, this out of these first 12 members, 10 of them has filed a writ petition, and this honorable court, page 323, has passed an order dated 19/10/2023.
nineteen ten to
2023. Page
Ah.
323,
okay, Mr. A. Viswas.
my lord.
In page 300, you are in which category? Within
We are in the second
1 to 12
category,
or 1 to 21?
1 to 21.
1 to 21.
Out of 21, 17 has preferred this writ petition.
Okay. And who are the petitioners here in this case?
This
Page
first category,
326,
first category out of
that
12,
1 to 12.
1 to 12, out of 12, 10 has filed that writ petition.
Yes, Mr. Borua. Bobruzari. Revenue that 30 biga. What is the name of the society? Purbanchal.
Is well aware, it's of that matter. Well,
They are showing some semblance of their rights that they were allotted some plot by the society. So
some plot, now they are my lord in Purbanchal Grihaneman Society.
their claim is through Purbanchal society. Not directly against you,
Right.
but through Purbanchal society. And similar petitions have already has already been preferred.
My lord,
Page 325.
yes, lordship maybe,
Please have a look.
yes.
They are seeking limited
Yes, madam. My lord, and,
relief in the form of interim relief.
my lord, all the,
Go to that 325.
Yes.
Any more? You want more?
no, my lord, all the three writ petitions are tagged together and on 17,
Let
11,
us have this.
my lord,
Let us pass this order before in this writ petition.
my lord,
Lordship maybe please to issue notice of motion here, my lord.
And
Much
similar relief.
my lord.
Similarly, my lord, lordship will kindly appreciate in that Purbanchal Grihaneman, everything is well identified. The quantum of land is identified. It is 30 bigas of land, my
No,
lord.
no, so they are not disputing about this 30 biga. They are seeking the relief, page 327.
No, Purbanchal Grihaneman on
They
their.
will be hard. Everybody has a right. As a person interested, they want that they should be hard.
Yes.
It is not regarding acquisition of land.
Yes, now there is a.
It is disbursement of the compensation or apportionment of the compensation. They say that they want to stake their claim.
Now,
That's
once my lord,
Is it not?
the move from the government is known to all the people, now people are coming.
Yes, their
That's what.
numbers will be added.
Yes,
Yes.
Mr. Dhor is also jumping the bandwagon. I heard Mr. A. Dhor, learned counsel for the petitioners. Oh. Mr. R. Borbuzari, Standing Council, Revenue Department for the response number 1 and 2. Also finance?
So Lordship may kindly record the name of my colleague because I cannot appear for both the departments.
Okay.
He will appear for it.
A. Bhorasaiji,
My lord.
Standing Council, Revenue Department for the response number 1 and 2.
My lord.
R. Borbuzari, Standing Council, Finance Department for the respondent number 3.
And so.
S. Borua, Junior Government Advocate Assam for the response. Oh, you are GDD also?
No, my lord. GDD is.
Okay. Mr. S. Borua, Junior Government Advocate Assam for the respondent number 4. And MS S. Chotia, Council representing Mr. P. Nayak, Standing Council GDD and GMD for the respondent number 5 and 6.
My lord.
Full stop.
Purbanchal, what is it?
It is,
Yes.
it has been stated that the respondent number 7, comma, a registered society, comma, was settled with a plot of land measuring 30 bigas covered by DAG number 1074 old stroke 3785 new and periodic pata number 1370 located at village Hengrabari, Mauja Beltola, district Kamrup Metro. When?
My lord, it's 1/4/1996.
On 1/4/1996. Full stop. Subsequent to settlement of the subject plot in favor of the respondent number 7, comma. The respondent number 7 society entered into registered deed of declarations, comma, all dated 19/2006, separately with 33 number of members of the registered society, and the petitioners herein, how many? 17 in number,
17.
comma, are among those, oh, sorry, 21 numbers. 21 number of members. Full stop. The registered deed of declarations were entered into for allotment of a plot of land measuring 1 katha 10 lesa each to each of the 21 number of members, and the petitioners herein, comma, 17 in number, are among those 21 number of members. Full stop. Para. As the subject plot has been brought within the purview of,
Water bodies.
what is the name?
Yes. The name is.
Guwahati Water Bodies within bracket Preservation and Conservation Act, comma, 2008. 2 writ petitions. The respondent number 7 society, as the writ petitioner, had preferred a writ petition, WPC number 7457/2018. Right?
Yes.
Seeking exclusion of the subject plot from the purview of the said act, which also includes the plots of land allotted to the petitioners herein by the respondent number 7 society. Full stop. During the pendency of the said writ petition, comma, it has been the decision has been taken by the state government to acquire
Yes.
the subject plot. Where is that observation?
My lord.
To acquire the subject plot.
315 page.
Well, 335, page
Ah.
335.
To acquire the subject plot, and such process has already begun by issuance of a notice under section 3 within bracket 1 of the Assam Land within bracket Requisition and Acquisition Act 1964, by registering a case, comma, LA 35/2023/463, right?
Yes.
Well, it will be only LA 35 of 2023. That is the LA case. And this is, my lord, the reference of the
Okay,
notification.
LA 35, by registering a case, LA 35/2023.
My lord, my lord.
Full stop. Para, the page 2326. The petitioners have approached this court apprehending that the state would acquire the aforesaid plots of land, the subject plot, by denying just compensation to the petitioner. And the petitioner, so it has been contended on behalf of the petitioner that they are also persons interested insofar as the acquisition process is concerned, as they have acquired some semblance of right by virtue of the deed of declarations entered into with the respondent number 7 society. So it has been thus urged that the respondent number 7 society may not be paid the compensation by ignoring the claims of the petitioners. Mr. Dhor, learned counsel for the petitioner, has submitted that the respondents, state respondents, while proceeding with the matter of this assessment of compensation, assessment and disbursement of compensation, comma, the petitioner should be served prior notice petitioner should be served prior notice. As so and so, so and so. Mr. Borpujai, learned counsel for the learned, sorry, Mr. Bhodasaiji, learned so and so, and Mr. Borua, and MS Setia have submitted that the process of acquisition will be carried out by adhering to the extant provisions of law extant. In view of the fact situation obtained projected above, comma, let notice be issued. Any fixed date in the other cases?
No, my lord.
Huh?
No, my lord.
Let notice be issued. The notice is made returnable on 24/1/2023. Since so and so appear accepted notice, the petitioner shall take state for service of notice upon the respondent number 7 by registered post with AD within 2 working days. In view of the case projected on behalf of the petitioner and considering the fact that the process for acquisition of the subject plot has already been initiated by issuance of a notice under Section 3(1) of the Assam Requisition and Acquisition Act 1964 by registering a case, LA case number so and so, it is hereby provided that no amount of compensation for acquisition of land shall be released to any of the parties without leave of this court. Same order.
Same order. Only, my lord, one submission, my lord, may we please to keep the maintainability of this petition open.
I have not kept your name. I have kept Bhodasaiji, Borua, and Sutia. I have deleted your names. That by adherence to the law.
Because alternative remedy is applies.
It would be, I think, better if
Yes.
I think Mr. Kyle is on the is present on the other side. Otherwise, he has to respond. Yes, he has come.
I think my learned friend, that's why I pointed out before the beginning of the case that there is a statutory appeal 86 of the Act. So without invoking the statutory appeal, by efficacious remedy, we have come up before this court. So that is the first I have to satisfy before this court. Without going to that, I have come by way of 226. If it is without wholly with a jurisdiction, then of course, with great respect, first point, then you have to don't satisfy the other points. If it is wholly also without
You have
jurisdiction.
come at what stage?
My lord, after the first appeal. After the appeals, first commission of appeal. My lord, adjudicating authority initially demand notice by the assistant commissioner. Against that.
You participated in that proceeding?
Yes. Against that, before the commissioner appeal, we have taken the point of jurisdiction. limitation, jurisdiction point. That part, that particular point was not decided by the commission.
What is the jurisdiction point you have issued,
Jurisdiction point we have taken?
raised?
My lord, there are two, my lord, there is an act. I'll just brief my lord. There is 73(1) of the act, 73(1) and
73(1) of which
of
act?
the Service Tax Act, Finance Act 1994. Now, in that it says that,
Finance Act.
I'll just tell your lordship, then we will just go to that act, my lord. That act says, my lord, within 30 months from the date, relevant date has been defined under 73(6). Now, my relevant date of furnishing the financial year was 2015-16. So 2016, I made a particular declaration before the tax department that this is my gross income of 40 crores something odd amount. Right, my lord? Now, what they have come to know, GST has said in the demand notice, which is of 2021, that in 2016, you paid a service tax of on the basis of service tax of 31 crores, you paid. But on 9 crores odd amount, you did not pay the service tax. You paid VAT, that's why you made an evasion. That's there's sum and substance of the demand notice. Now, 73(1) says, from the relevant date, that is 2016 June, within 30 months, you have to initiate a demand notice and give a show cause to the party. 30 months. This is one. Proviso 273(1) says there are 5 different conditions where they can initiate. That limitation has been given to the department. These 5 conditions, 5 years time has been given to the department under the proviso. One is 30 months, 30 months on a different ground altogether. Limitation of that 5 years under proviso is on 4-5 grounds. One of the ground is fraud, collusion, misrepresentation, suppression of facts. So if there is a suppression of facts or fraud, collusion, then they get the benefit of the 5 years. Extended limitation, my lord, they get the benefit. Now, it is 2016, June 2016, the relevant date. So, number one, they should have initiated within 30 months, which they have not done it. They brought the help of that limitation, extended limitation, because now they are alleging in a demand notice that is an allegation of suppression of facts. This is what they brought by the adjudicating authority. Initial is the Assistant Commissioner of Tax. Now, his allegation is suppression of facts, but our case is that he has not allegation of, you can't make only an allegation. It has to be established. Established in the sense A, B, C, D, E, F with a reason. This he has not done it. We preferred, against his order, we went to Commissioner of Appeals. There they have taken that point, that it is limitation within 5 years. It is within 5 years, but they have to exercise their mind with a reason order and establish that this is the suppression of facts. Now, it is not a case where on a 9 crores an amount, which they are saying that you have evaded tax, we paid VAT. VAT has been accepted by the government. It is not that totally, we paid the VAT on 9 crores. Why? There are 2 legs of argument. First leg of argument is the service tax. Second is that 9 crores amount, on papers we said, this is a supply which has been made to the government. Sale to the government, government accepted it. And on that acceptance, we paid the VAT. And VAT has been accepted by the government. So where is that question of suppression of facts? And if it is allegation of suppression of the facts, you have to establish. If you don't establish, my lord, then it is wholly without jurisdiction you have issued this so-called. You have the jurisdiction, but that jurisdiction has to be not only allegation, that has to be established by them. So on this count, my lord, I have approached the Commissioner of Appeals. Now, Commissioner of Appeal Now he doesn't decide this issue at all. He keeps quiet. I'll show it, my lord. He doesn't decide on that issue. Regarding about that, the jurisdiction on that part, that limitation, my submission, you took the help of limitation of 5 years because you didn't have any alternative because 30 months, so let us take the help of that 5 years. But taking the help of 5 years, allegation will not do. They have to establish. From where I am saying, my lord, you have established 2-3 judgments I tried to find out. One is a judgment on the basis of principle of law. Another judgment I found in Calcutta High Court on this issue on the same subject matter. Same subject matter. Of course, I told at the very first instance, my lord.
There is what?
There is an appeal.
What is the so-called notice?
No, yes. Now, my lord, one more thing, my lord.
Because it appears from your submission
Yes.
that after issuance of so-called notice,
Yes.
you submitted to the jurisdiction of the officer,
Correct. Yes.
that authority,
Yes.
original authority,
Yes.
adjudicating authority.
Yes.
You contested the case.
Adjudicating authority, my lord, has not kindly seen that the
Then
first.
thereafter, order in original.
Yes.
Thereafter, you preferred appeal,
A commissioner to the
appellate authority,
On the-
invoke the appellate jurisdiction.
on the point of jurisdiction. On the point of jurisdiction, my lord, the limitation point, kindly see that, my lord. Page 85, my lord. Your
So,
lordship want.
your point of challenge, not directly initially,
No.
at the first point of time
No,
after
no,
receipt
no,
of
no,
the so-called.
Not initially. Not initially. That I'm
So-
saying. I said very beginning, my lord.
You
not initially.
submitted to the jurisdiction of the adjudicating authority.
Absolutely correct.
Thereafter, the appellate authority. Now there is another authority.
It's a tribunal against this order.
Right.
So without going to the tribunal, whether your lordship can adjudicate this matter. This is the whole case, my lord. Now suppose tomorrow your lordship says, will not adjudicate your matter. It is your tribunal. Second, my lord, my argument.
Suppose we decide this way or that way.
My decision,
Decide this way or that way. Suppose it is decided against you, whether at the point of limitation for preparing the appeal, what would be the
no,
answer?
can I say one other way, my lord? Other way.
Suppose it
No,
goes against you.
No, suppose your lordship decides, your lordship says that yes, there is a violation of principle of natural justice in this case. That also your lordship can invoke.
That is one side.
No, first, your lordship said, no, absolutely, we are not going because this is what it's statutory appeal remedy, not satisfied on the point of limitation, jurisdiction. Then your lordship has to decide against it. One. Suppose without going to that aspect, one aspect, saying that I can show that there is a principle of natural justice, where at the time before the Commissioner of Appeals, we have sought for time to produce certain documents which we have brought before the court. And we told the Commissioner of Appeals that during the course of hearing, the session is going on. Please give us some time to produce the document, whether and it is a sale or not, we have sale or not, that we want to produce. He didn't give time. In 3 days, he decided the matter against me. So without deciding limitation and also without giving us time. So if your lordship now thinks that no, what we'll do is limitation part, of course, I will satisfy your lordship. And without touching all this, you go back to the Commissioner of Appeal. We are, of course, I have to satisfy. There is a violation of principle of natural justice. So these
There
things
could
are
be two
there.
questions to it.
Yes.
One is violation of principle of natural justice has two parts. One is absolute violation of principle of natural justice,
Yeah.
or no proper opportunity or adequate opportunity. First part, yes. All these decisions are about absolute violation of the principles of natural justice. Adequate, proper, all these things are not very straightforward formula. But it is not that, is it a
Again-
case that not at all hard?
No, Absolute, there is no question of that I was not heard. Only during the course of hearing, certain documents which have been sought for, that opportunity was not given to me.
Let us see the point of limitation.
Yes. Can I just show first the basis of the so cause? Then I think your lordship will be able to.
Otherwise, I have already observed in other case, I think it has been placed before me,
Yes.
that in similar situation, we have said that
Yeah.
it should be, appellate tribunal should have been
Yeah.
proceeded.
Yeah.
That is, I think, just he has placed.
No, I have, that's why I said, my lord.
Yes, yes.
I also agree to it, my lord.
Let
That's
us
why
see the.
my first argument before your lordship was that. I am also aware of it, my lord.
Let us see the point of limitation.
Yes, limitation, kindly see the act, my lord. That first your lordship will. No, but your.
Gone.
Yes. No, no, yes.
Okay.
Kindly see 73, my lord. I think that will, then we will connect. Section 73. At page 16. At page 16 down below, bottom.
Yes.
Section 73. Recovery of service tax not levied or paid or short levied or short pay or erroneously refunded. Number one, where any service tax has not been levied or paid or has been short levied or short paid or erroneously refunded, Central Excise Officer may within 30 months from the relevant date serve notice on the person chargeable with the service tax which has not been levied or paid or which has been short levied or short paid or the person to whom such tax refund has erroneously been paid, requiring him to show cause why he should not pay the amount specified in the notice. So my lord will kindly see the first part, 30 months from the relevant date. Now kindly see proviso. Provided that where any service tax has not been levied or paid and has been short levied or short paid or erroneous refunded by reason of a fraud or collusion or willful misstatement or suppression of fact or contravention of any provision of chapter or of the rules made thereunder with intent to evade payment of service tax. Be the person chargeable with the service tax or is in the provision of the subsection shall have effect as if for the word 30 months, the word 5 years has been substituted. Now, where the service of notice is so and so, so and so. Now your lordship will find 73.6 at page 18. 73.6. My lord, we are by A, covered by A. For the purposes of this section, relevant date means in the case of taxable services in respect of which service tax has not been levied or paid, has been short levied or short paid, A, where under the rules made under the chapter, a periodical return showing particular service tax paid during the period to which the said return relates is to be filed by an assessee. The date on which such return is so filed. Now, my lord will kindly note down my relevant date is for the year 2015-16, which your lordship will find at page. See the so cause, my lord. Now kindly see the so cause at page 35. My lord, dated is 26/4/2021. If you take 26/4/2021, my lord, it is within 5 years. Just before 26/4, where it appears, because your lordship will note down June 2016, I file my return, last return. Whereas it appears that so and so, Bora, hereinafter refer to a notice holding service tax, registration number are falling within the jurisdiction of Artswise Central Notice Service Tax, have provided taxable services other than those specified in the negative list of services under section 66D of the Finance Act 1994 during the financial year 2015-16, where it appears the notice has suppressed the actual value of services provided during the financial year 2015-16 and did not fully disclose the liability in their ST returns of the said year and have consequently short paid service tax due to the turn ST3 returns of the said year, have consequently short paid service tax due to tune of 1 crore 34 lakhs 54,383 only in violation of section 66B, 67, 68 and 70 of the Finance Act. So this is the allegation which has been leveled against me. Now this matter, and my lord, invocation will find at page 36 on the last 4 lines. At page 36, last 4 lines, was required to be paid by the said notice to the government exchequer which they failed to pay, hence the same is required to be recovered from them under the proviso to provision to section 73(1) Finance Act as amended by invoking extended period limitation along with interest at appropriate rate under section 75 of the Act. Now this was adjudicated by at page 50, it starts from page 47, it starts. Your Lordship just can mark it page 47. It the adjudicating authority at page 51, 4.2. At page 51, 4.2. It was alleged that on scrutiny of the said information received from Income Tax Department, it was found that the notice contravened the provision of section 66B, 67, 68 and 70 of Finance Act, read with Rule 6 of the Service Tax 1994, inasmuch as they did not fully disclose their liability in their ST3 returns of the said period and thus suppress the actual value of taxable service provided during the financial year 2015-16 and consequently did not pay service tax due to a tune of rupees 1 crore 34 54,383 during the said period payable on differential taxable value of 9 crores 27,88,851. Now it was proposed in the said so-called notice to recover the said amount of service tax invoking extended period in terms of provision to subsection 1 of section 73 of the Finance Act along with applicable interest in terms of section 75. Penalty under section 78 was also proposed to failure to pay service tax within due dates and for suppression of vital facts from the department with intent to evade payment of service tax. So only is a reproduction of the so-cause which has not been adjudicated by the authority. Whatever may be, my lord, whatever may be, this was an appeal was prepared before the Commissioner of Commissioner Appeals, Commission of Appeal, page 64. Page 64. Page 85. Is our one of the main ground on the point of limitation. Page 85. 12.0. For that the impugned order in original dated 1/3/2022 based on so-called notice dated 26/4/2021 is not sustainable on the ground of limitation. It is to mention here the period of this dispute is for the period from April 2015 to March 2016, and the appellant has filed a periodical ST3 returns for the period of half yearly ending September 2015, March 2006 revised on 25/10/2015 and 26/2016. Moreover, the income tax return for the period 2015-16 was filed long back in October 2016, whereas the so-called notice has been issued on 26/4/2021 upon the impugned order in original passed on 1/3/2022 by invoking extended period. In the present case, there was no suppression of any kind
whatsoever, as the appellant was registered under service tax, paid the service tax liability on time, filed their service tax return as and when due, since the demand is primarily based on income tax return and Form 26 AS, the information of provision of service as well within the knowledge of department, as IT returns and information therein forms part of the government records, alleging suppression is not proper. The allegation for extended period thus do not arise in such cases and deserve to be dropped fully. Now, this is how it is decided on this. Page 90, kindly see, my lord. After hearing, it was heard, my lord. During the course of the hearing, my lord. During the course of hearing on 15/6/2023, my lord, I told the commissioner, request you to kindly give some time to me for getting the documents required by you, as I need to collect from the department concerned. As the Assam Assembly is going on, department will take some time to issue the document. Document is required for more clarity as per the scope of the work. Now, my lord, this is, they have received on 18/9/2023, my lord. Now, what has happened, why we have asked for, to show that doesn't fall under service tax. For that purpose, we have paid VAT. Now they want this, all the document to show where is the scope of work. Now we said that please give us time. Now 21, after 3 days, my lord, at page 91, he decides. At page 91. Lordship got it, my lord? Page 91. That's the order on 21/9/2023. Kindly see on the,
So it is about 1.5 years.
I'm sorry.
The appellate proceeding was for about 1.5 years.
Yes.
Now, just before, after conclusion, whatever,
Not conclusion.
whatever,
hearing.
that order in original was passed on 1/3/2022.
Which one? Oh, earlier.
Yes,
Yes.
47.
Yes, sir, that's not.
You preferred an appeal
Yes.
within the period of limitation. That appeal was entertained. Then it was heard. Let us see the appellate order.
No, during the course of hearing, my lord.
Right.
Yes.
That is why.
101.
Let us see where is the reflection in the appellate order.
101.
The petitioner was heard. It has started from which page?
Yes. Page 101, para 11. It is not been reflected also that we sought for some time before the Commission of Appeals.
Let us see where is the reflection that hard.
Para 11, my lord.
Para
11. At page 101. 101.
So personal hearing was afforded to you.
Yes, yes.
On few occasions.
Well, that's why your lordship said there are two parts. One is absolute. Secondly is what I am calling on the second category, that during the course of hearing, I sought for certain documents to be produced.
By the order in original, you were quite aware that what are the deficiencies you have to meet.
No, my lord.
That part that regarding the demand come show cause notice, this original authority had adjudicated by the order in original. Right?
Yes.
So the deficiencies you were required to meet, you were quite aware of.
No, my lord.
Why at the last moment?
At the course of hearing, the hearing took place. There is always an interaction. Now, my lord is interacting with me. During maybe a 15 days hearing may go on. Interaction, your lordship may require certain documents. Lordship, for the end of justice, your lordship gives time that you produce this particular document, my lord. This is what we have asked for.
This page 90 is quite vague.
Page
90.
Yes.
What kind of document?
My lord, they are not, my lord, the problem is they are not the lawyers, my lord. Some personnel, they went and, my lord, if it had been given to a lawyer, then it should have been fully, my lord, what we are saying limited, give us some time to clarity as more the scope document required for the scope of work. Now, I have brought notice to the court now before this court, my lord, additional affidavit. What is the scope of work? Now, how it has been dealt at page 101, kindly be seen, my lord. 101. My lord, I made a particular point of limitation. See, kindly say 10.13. The impugn order in original dated 1/3/2020 based on so-called notice dated 26/4 and 26 is not sustainable on ground of limitation. It is to mention here in a period of dispute is for a period for April 2015 to March 2016. Appellant has filed her periodical ST returns of the period of half year ending September 2015, March 2016 revised. So moreover, the income tax return for the period 2015-16 was filed long back in October 2016. Whereas the so-called notice has been issued on 26/4/2021, upon which impugn order in original passed on 1/3/2022 by invoking extended period. My lord, this is my submission. In the present case, there was no suppression of any kind whatsoever as the appellant was registered under service tax, paid this service tax liability on time and titled the service tax return as and when. Since the demand is primarily based on IT returns and Form 20, the information of provision service is well within its knowledge of department as IT return information therein forms part of government records, alleging suppression not proper. Allegation for extended period do not arise in such cases and so drop fully. Now, my lord, my lord, kindly see page 12, finding, kindly see from tail 12, finding. I find that the appellant, against the demand of service tax raised on them as submitted before the adjudicating authority, a differential turnover of so on which the demand of service tax was raised for the years was on account of sale of goods on which VAT was payable. The remaining amount was bank interest. They further submitted the explanation in this regard, a record in para number so. However, the adjudicating authority at para 4.5 of the impugn order clearly observed the appellant apart from mentioning this amount relates to making and sale of hoarding on which VAT was deducted by the service recipient. Department of Information and Public Relations Officer refrained from furnishing further information document like detailed nature of work, copy of the work, order or supporting detail. In absence of any kind of supporting document, the adjudicating authority was constrained not to accept the claim of the appellant. So that is why, my lord, I have sought for time to produce all these documents. Kindly see, in this regard, 13, I find the appellant time of hearing at appellate has submitted copy a single page work order, award of order from Director of Information Public so for award of work for multimedia campaign so. As per this document, the awarded work was for conceptualization, execution of media buying working plan for dissemination of government-related information through various media platforms like electronic media, outdoor publicity for multimedia campaign, Vision Assam, for limited information available from this document. The only inference can be drawn in the appellant awarded contract for designing and executing media campaign through various media platforms. Such activity clearly appears to be nature of advertisement service. Service tax was payable even if the activity involved transfer of some good. In any case, no further details have been so appellant this award of work. Based on, I am inclined to believe that so appellant relation differential turnover was clearly covered under so. Limitation, we must not at all cover, was considered, my lord. My limitation was not considered. My lord.
Apparently, these are questions of fact.
No, my limitation was
There are
not
13. These are questions of fact which we are not required to be gone into in extraordinary jurisdiction.
I am not saying that. My argument is my limitation has not been discussed. That's the point of jurisdiction, my lord. He has to decide. Then I have no problem at all, my lord. Why my particular that point of limitation where it has been filed is I said what? Suppression of facts. It is not only alleging, it has to be established where it has been discussed.
What is the law
Yes.
regarding suppression of?
Yes, I'll just one judgment
two judgment. My lord, can I first show the Supreme Court judgment? Then I will show the Calcutta. There are 2021, what are the principles that have been laid down by the Supreme Court? 35 and 36. Paragraph 36, kindly see.
No, this is matter of revenue.
No. Revenue cases.
Revenue cases are different from other
I will say
cases.
Calcutta, then your lordship, no, I just saw the principle. Principle, kindly see one paragraph.
This is a
36.
matter of auction purchase.
No, I will just tell what is the principle, my lord. 36, my lord. Para 36. As per settled principle of law,
Tera?
36.
I think this judgment has been deferred with in some other judgment. This I have,
This is one.
because in dealing with some other cases, I have seen this judgment.
I really.
It has been discussed in subsequent judgment.
Yes.
I'm just, I'm not, cannot lay my hands
Yes.
just now. Yes, let's read 36.
As per the settled principle of law, when fraud is alleged, because they are alleging, my lord, the suppression, the same is required to be pleaded and established by leading evidence. Merely allegation that there was a fraud is not sufficient. Therefore, subsequent order passed by the High Court calling for report from the learned principal city civil judge on the question whether degree was obtained by fraud or not can be said to be given opportunity judgment data fill the lacuna. Therefore, the court set up the High Court calling from the report from the learned principal cannot be approved. What I want to say, mere allegation which they have made, my lord, that is not because it's their case. They have to establish, my lord. Owners lies to department. My lord, now I will show. Well, I will just check it. Your lordship has said that is.
Maybe this is my.
No, I will definitely look into it, my lord.
In the
Now, kindly see.
short memory.
No, my lord. There is a judgment of Calcutta. Yes. 2016, that's on revenue, I think same, service tax. Correct, no? 55. 55 na 57. क्यों नहीं लगा? 57 kindly be looked into in my lord. Lordship got it? 57. 57.
At what stage it has come?
This is on the point of the limitation period.
No, at
Extended
what stage
limitation.
this petitioner came?
No, they came only on the ground that it is beyond the limitation period.
At the stage of show cause notice.
Yes, so cause notice. But what the law that has been laid down, 57 kindly be looked into it, my lord. My lord, the question is whether department was justified in invoking the extended period limitation for the purpose of issuing the impugned so cause notice. I am of the view that there were a mechanical reproduction of language of the proviso to section 73(1) of the Finance Act does not per se justify invocation of the extended period limitation. A mere ipsi dixi that a notice willfully suppress the material fact with intent to evade payment of service tax is not sufficient. Notice must contain particular of facts and circumstances in support of such allegation. If such particulars are not included in notice, department should be in position to justify and or substantiate his allegation of suppression of material facts on the part of the notice. only mere allegation will not do. They have to, definitely they have to exercise their mind, which has not been done in the instances. So if there extension of limitation, my lord, if you can't, then he is wholly without jurisdiction, my lord. So he has to act within a period of 30 months. Para 67. Para 67. Proposition which emerges from the judgment of the Supreme Court referred above is that failure to disclose the transaction, pay tax thereon, or a misstatement or mere contravention of the Central Excise or the Finance Act is amended or the rules framed is not sufficient for invocation of the extended period limitation. There has to be a positive, conscious, deliberate action intended to evade tax. For example, a deliberate misstatement or suppression pursuant to query in order to evade tax. Now, what my argument? Well, let them decide, the Commissioner appeal, my lord, in the point of judicial limitation. And also, I have paid the amount, my lord. Before the Commissioner of Appeals, I paid the amount. Deposit, pre-deposit, I made it. So on these 2 points, he can decide, my lord, on the point of limitation and on the point of that giving me an opportunity to produce the document which I produce here, my lord. Additional affidavit. I will not produce even a single document which is not a part of here, my lord.
What is the presumption that Sestet will not consider these points?
Which one, my lord?
These 2 points.
No, what I want.
Question is, what is the presumption that the Sestet would not consider these points if he hesitated before the Sestet?
No, authority doesn't decide it. That's why I'm saying let them decide it. My lord, normally what it does, if it doesn't decide it, your lordship can remand this matter to the authority to decide these 2 points. Either you give me a chance of producing this document, and if you say that no, I am not accepting your document, that's the end of the matter. I have taken the plea, my lord. It's not that I am not
Do you
taking
have any authority of the Supreme Court
on this which point, my lord?
on these points?
Finance-
Limitation point,
Limitation.
suppression of fact. That may be a persuasive one. And that case came at the stage of show cause notice.
Yes. That's why I said, my lord, let it go to the Commissioner of Appeals, my lord. And I will just place it. Let him decide the limitation part. Natural justice, he has to give it,
Yes.
my lord. At least once only
Gone
natural
into-
justice.
Anyway,
Lordship has seen the ground in the demand comes out of notice, Lordship. May come to page 37.
My lord, 1 second, only 1 second. Your lordship say any judgment of the Supreme Court. In this, while deciding the Calcutta High Court judgment, they refer to a judgment of the Supreme Court in para 64. Quoted 64. 64, my lord. Para 64. Lordship got it, my lord. The collector of so and so, in order to make the demand for duties substantial beyond the period of 6 months up to the period of 5 years, in view of the proviso to subsection 1 of section so and so, has to be established. Duty of excise has not been levied or paid or short levied or short paid or erroneously refunded by reasons of either fraud or collusion or willful misstatement or suppression of facts or contravention of any provision of the Act or rules made thereunder with intent to evade payment of duty. Something positive other than mere inaction or failure on the part of the manufacturer or producer or conscious or deliberate withholding of information when the manufacturer knew otherwise
is required before it is settled with liability before the period of 6 months, wherein a particular set of facts and sir, there was any fraud or collusion or willful misstatement, or sir, there was any fraud, suppression or any provision act, is a question of fact depending upon the facts and circumstances of a particular case. Now, another judgment of Supreme Court has been mentioned in 65. 65. We find the suppression of facts can only have one meaning, that the correct information was not disclosed deliberately to evade payment of duty when facts were known to both the parties. Omission by one to do what he might have done, not that he must have done, would not render a suppression. It is a settled law. Mere failure declared doesn't amount willful suppression. There must be some positive act from the side of the essay to find willful suppression. Now, ultimate paragraph 67, the proposition which emerges from judgment of Supreme Court referred, it is a mere failure to disclose a transaction and pay tax thereon, or a mere statement, or a mere contravention of the Central Excise Act of Finance is amended. Any rule framed thereunder is not sufficient. Invocation of the extended period limitation. There has to be a positive, conscious, and deliberate action intent to evade tax. For example, a deliberate misstatement, suppression pursuant to a query in order to evade tax. All my returns have been filed. If there was from my side to evade tax, my lord, then I would not have paid VAT also. I paid VAT on 9 crore something odd amount. What I'm submitting before your lordship with great respect, that let it go before the Commission of Appeal. Let them decide on these two aspects. One is whether all those documents, let me submit and let him decide on the point of limitation point. These two are the only what I am asking before this court. At least we'll get a chance there. Now your lordship said there is a tribunal. At least if it goes against us, my lord, it will go against us. Then we will go before the appropriate tribunal will go, my lord. At least let me project my case, my lord, by filing those documents.
So does come to page 37
Of my lord.
of
Of the
the
rate petition.
rate petition.
Page 37. Yes.
At least he has given the reason why he construed it to be a case of suppression of fact.
Well, my lord, page
Page
37.
37, read last three lines.
Yes.
One last para has been
Page 38. 37.
37, last three lines. It starts from last three lines. And at least
As per section 71, as per 70, as
yes,
per section 71 of the Act, every person liable to pay service tax shall himself assess the tax due on services provided by him and shall furnish the superintendent of central excise a return in such form and in such manner and at such frequency as may be prescribed. Since the introduction of self-assessment, it is once of every service provided to correctly assess the service tax due. On his own accord, the correct value of services provided and the appropriate tax thereon had to be declared in ST3 returns file. However, in the instant case, as explained in the foregoing paragraph, it is observed a notice has misdeclared his service tax foregoing paragraph. It is observed that notice has misdeclared service tax liability. Had the data from income tax authorities have not been available or scrutinized, it would never have been possible to know the actual gross value of service provided by notice, which is much more than what he declared in ST3 return, does it appears that a notice suppress willful misdeclared defects in the services tax return filed by department in contravention of the provision of section 67, 68, 70 of chapter 5 of so and so, thereunder the intent to evade payment of, it is for reason provision of so and so for invoking the extended period is unambiguously applicable in the instant case, and hence invocation of the extended period is amply justifiable.
He has devoted one full paragraph
No.
to justify his action.
But-
His
but-
regions assigning may be wrong.
Yes, right.
Right. He is assigning the regions may be wrong. But that does not mean that he has not dealt with the issue.
But my lord,
He has dealt with the issue.
your lordship is right. The reasons which he have assigned may be wrong.
May be wrong.
May be wrong, maybe. So we have gone before the Commissioner of Appeals. Now Commissioner of Appeal kindly see, my lord, how he dealt with. My lord, I have taken a specific limitation point. He could have dealt with that, my lord. Only what I am praying, my lord, I am not praying. I am only praying that let it go before the Commission of Appeal. Pre-deposit has been made.
So far, original authority has dealt with the issue. Maybe this is unsustainable.
No,
That does not mean
No,
that
I am not saying, I am gone
he has
against.
said that this 5-year period, extended period is justifiable. That is what
I
he
went
has-
before that order. Now, where is that judgment passed by the Commissioner of Appeal, my lord? That particular limitation point. He has to deal with, my lord. I am aggrieved by that. I went to Commissioner of Appeal, my lord. I have
You have
dealt
to-
with,
I have not read this. I have just read now
yes.
this paragraph.
But ultimately,
Yes, dealt,
ultimately,
maybe.
ultimately, we are on the point of how it is being dealt by Commissioner of Appeal, my lord.
We'll see then at two, because I have not read it. This I have seen, order of the original authority. Now he has assigned region. That may not be acceptable. But that does not mean that he has not
I
justified
know what I am saying.
from his
You know
perspective.
what I am saying, my lord, what I am saying, my submission is that we preferred against his order before Commissioner of Appeal. Now, Commissioner should
I
have.
haven't gone into,
Yes.
I'll have a look
Yes,
and I'll ask
yes.
queries.
No, of
So
course.
far, adjudicating authority, original authority is concerned, he thought it justified to invoke that extended period of limitation. Right or wrong, that is a different issue. That part I am satisfied. Adjudicating original authority. Primacy. For entering the writ petition or not to enter in the writ petition, not on the merits. So far, original authority is concerned.
No, I am not.
We'll have a look at the
No, I
appellate
am not
order.
disputing of the original authority. What I
Now,
am
we'll
saying.
have a look at the
Yes.
appellate order
Yes,
after. If you are available at 2.
yes.
Petitioner is also a lawyer of this honorable court, my lord. It is used as his advocate chamber, that construction part.
Okay. Try to bring.
My lord, I'm deeply obliged, my lord.
One point you were saying that about jurisdiction.
Yes.
Second is natural death. Okay. Yes, Mr. Gayal.
Lordship. Lordship has seen page 37.
Yes.
With regard to extended period of limitation, Lordship, the notice it has been stated by. And similarly, Lordship, order in original. That has been discussed. Lordship may come to page 50, the type copy of order in original.
50, yes.
Paragraph 2, personal hearing of the case. Lordship what? Held on 17/2/2022, hearing Sri Ankit Agarwal, tax consultant, authorized representative of APEC before the executing authority. He claimed that the liability of service tax has been discharged on actual value of service amounting to rupees so and so, and presented a breakup. He also submitted a written reply along with supporting documents, namely balance sheet, profit and loss account, Form 26 AS and SD3 return to justify his claim. The brief of the written reply dated submitted during the course of hearing as follows. You can skip Lordship. Then Lordship, may come to page 51, discussion and reasoning.
No, no, no. Go ahead, go ahead. Yes, page.
Page 51, Lordship. Page 51. Discussion and finding of the executing authority. Lordship, may come to paragraph 4.2. It was alleged that the scrutiny of the said information received from Income Tax Department, it was found that the notice contravened the provision of section 66, 3, 67, 60 and 70 of the Finance Act 1994, read with Rule 6 of the Service Tax Rule 1994. In as such, in as much as they did not fully disclose their liability in their ST3 return for the said period and thus suppress the actual value of the service tax provided during the financial year 15-16 and consequently did not pay service tax due to the tune of rupees so and so during the said period payable on different taxable value rupees so and so. Lordship knows that the entire service tax process is a self-assessment process. It is the SSC who has to disclose everything. And in return SC3, unless they disclose, it is difficult for the department to come to a finding that whether any suppression is there or not. In this case, Lordship, when we got the information from the Income Tax Department on verifying that, come to know that they have not disclosed in the facts. Now, Lordship, may come to section 70, Lordship. Section 70 of the Finance Act.
Finance Act, what to do? This one. What?
Finance Act 1994. My landed fund is given on.
That is what I am looking for it. That is Nikki. This one or this one is affidavit. Itu Calcutta hai. Put it. এখন আছিল তো এখন this one.
Lordship, yes. Lordship, may come to section 67 capital A.
67 capital A. Yes.
Date of determination of rate of tax, value of taxable service and rate of exchange. The rate of service tax, value of taxable service and the rate of exchange, if any, shall be at the rate of service tax, value of the taxable service and rate of exchange as the case may be, in force as applicable at the time when the taxable service has been provided as agreed to be provided. Then Lordship, section 70. Furnishing of returns. Every person liable to pay service tax shall himself assess the tax due on the services provided by him and shall furnish to the superintendent of central excise a return in such form and in such manner as and at any frequency and that and with such late fee not exceeding 20,000 so and so for delayed furnishing returns. So now Lordship, under the section, it is the duty of the SEC to file return and disclose everything. But in ST3, Lordship, it is admittedly, they have not disclosed the entire component of the service tax which they are liable to pay. Under section 71, Lordship, under section 73, the authority has invoked section 3 proviso.
Section 73.
Otherwise, we are 30 months. But in case of this fourth clause, Lordship may come to section 73 provided that where any service or tax has not been levied or paid or has been short levied or short paid or erroneously refunded by reason of fraud, collusion, willful misstatement, suppression of tax. Under C and D, the case of the which is a false fraud.
And appeal is under what provision?
Lordship, under section 68.
Hmm?
Lordship, I'm just. 86.
80?
84, appeal to the commissioner. Then 86, appeal to the appellate tribunal.
Okay, this appellate order is under section 84.
No, yes, Lordship, it is under 86. But it was passed by the commissioner appeals. Lordship. It was under 84. With regard to principle of natural justice, before the executive authority's ex-consultant appeared, and it is also reflected in the order also. And before the appellate authority, Lordship, one person, namely Kashyap Bezbarwa, he was the authority of the appellant, appeared for hearing on 39/2023. He submitted a copy of work order and reiterated the submission already on record.
On further appeal is under what provision?
Lots of, it will be under section 86.
86. Yes, anything in reply?
Yes, I just gave a reply. And then I told your lordship, kindly see my additional affidavit. Where my lord a chance was not given. And ultimately, these are my lord, fact that on the point of 9 crores I paid the VAT to the government. It is not that I didn't avoid paying. It is not that this non-disclosure. Page 112 kindly be seen, my lord. These are the documents which I could not produce at that relevant time at 113. 113 kindly see, my lord. 8 crores. 8 crores 76 lakhs at page 113. 8 crores 76 lakhs 29,918. VAT 5% is 41 lakhs 72,553 deducted. After deduction, I got this amount. And next, your lordship will kindly see at page 116. This is the amount where VAT has been paid. This is 63,52,500. VAT 5% is 302,500. 60 lakhs 50,000. At page 120 also, this is being paid. So it is not that on 9 crores, this is the 9 crores they are saying that I should have paid service tax. Now, if they levy service tax, it will amount to double taxation. Because I paid the VAT, because these, what I am saying, my lord, hoarding, kiosks, these are all of sale, my lord. This is not a service tax. This is our case before the authority, before the commissioner. So this is the documents which I want to produce. He can take a decision on this document, my lord. Let him take a decision on this document. I could not submit. So my prayer, limited prayer is that.
Come to page 36.
36. 36.
Third para.
Third paragraph, where it appears, notice was asked to submit certain documents by letter dated 4/9/2004 asserting his actual service tax liability during the financial year but he failed to submit the same till date of issuance of this notice. So
What about
this is,
your position, your reply to this?
my lord, I'll just give it reply. 44 is my reply. My lord, details I have given.
44 reply.
44, yes. Now this particular, kindly see, my lord, with reference, I mean received a so-called notice so and so. That the year 2000, my gross sales turnover, the period of 40 crore with detail below. Gross value of service, we said 31 crores. Gross value of which VAT is payable is 9 crores. So the total amount credited, so we have given details. 46, kindly see, my lord. Para 11. Para 11.
Those are questions of fact. We are
11.
on those four grounds. We are on those four grounds. These are facts.
Which are the grounds? Four grounds.
Basically, jurisdiction and
That's why I'm
natural
saying.
justice.
No, that is why we
Now
say.
come to page 48. Paragraph 1.1, last four lines. He repeated the same thing.
It appeared the notice contravened. So as must they suppress the
No,
actual
last four lines of that paragraph.
only on differential tax sale value of rupees so and so during
TC
the
was asked. 1.1 paragraph,
1.1, yes.
last four lines. The notice
But
was asked.
notice was asked to submit certain document white so and so for asserting the actual service tax liability during the financial year. Notice failed to submit the same. No, we submit, my lord, on the point of 31 crores.
Did you receive that notice or not?
My lord, page 70.
Let us see.
Page 70 in the AP. Para 2, my lord. Para 2. That for that the order in original dated is bad in law and as much letter bearing dated 4/9/2000 as referred in so and so said to have been issued for submission requisite document are never received by the appellant, which may be evident from the fact that the impugned so-called notice as well as order in original is constantly silent about the receipt or acknowledgement of the said letter. Therefore, the allegation of non-submission of document, non-payment of service and deliberate suppression value of taxable service rendered by the appellant with an intent to evade payment of service taxes for the period 2015 as mentioned and highlighted. Impugned order in original are vague, devoid of facts and unsustainable and without any basis.
Okay, Mr. Cal, find out that we'll take up tomorrow. It is never received. Find out, we'll take up tomorrow.
Then lordship on reopening day.
No, not reopening. Tomorrow.
Tomorrow lordship,
Find out.
no, lordship, there is no difficulty in finding out, but I'll not be here tomorrow, lordship.
You are not here tomorrow. Day after tomorrow you'll be available.
So lordship, on reopening day, lordship. On reopening day, probably these 3 days I will be some personal duty.
With the tribunal also.
No, that I'll, that is.
With the tribunal also.
It will sit at 4:30. I'll manage that.
No, not 4:30.
At 3:30. 3:30.
Yes. So your presence would be there.
No, that will be because I'll manage. Otherwise, I have some personal difficulties lordship, in 3 days.
Okay, we'll fix day after tomorrow. Find out if you are not available, then we'll
Then.
we'll take up at 2.
Day after tomorrow.
Tomorrow?
Day after tomorrow.
Yeah.
Yes, since he is not available.
No,
tomorrow.
absolutely no problem.
At 2 o'clock, we'll take up.
Lordship, I'll-
That is the understanding.
Yes, Lord.
Find out about this veracity of this statement.
Lordship.
We'll take up
No problem.
first.
No problem.
Heard Mr. Didas, Learned Senior Counsel, assisted by Mr.
K.
K.
Talukdar.
Talukdar, Learned Counsel for the petitioner, and Mr. S.C. Kyle, Learned Standing Counsel GST for the respondents. Oh. Wow, for the respondent number 1 to 3.
Lordship.
Why 4 and 5?
Lordship, for 4-5 days state,
State. Any state council.
Work order issued by the state. Work order, which work order was issued by the state for 9 crores. If tomorrow the work order has been issued, because we made state as a party, work order issued by the state and we are saying that it is a sale. And they have received it and in percentage we paid the VAT.
List the case again on Thursday for further hearing. Understanding is that we'll take up at 2.
Not. Deeply obliged.
একটু ফাইল থৈ দিব আৰু এখন কিবা দিছিল নহয় ফাইলখনত থৈ দিব কলিকতা এটা আছিল নে কলিকতাৰ ভিতৰত আছে নেকি Yes.
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 This I am allowed to implement the private respondents.
I have to see.
Seventy 21.
Heard Mr. B. Sinha, Learned Counsel for the applicants, and Mr. Raskwa, B. Raskwa, Learned Standing Counsel, Cooperation Department for the opposite party number 1, 2, 3, 4.
1, 2.
The applicants as lead petitioners, have preferred the connected read petition, WBC number 7240, 2023. To assail and to inter alia to assail. Which order you have assailed?
3/12/2023, Annexure 7.
There
Page
is no
34.
mention. There
Page
is no
34.
mention in the prayer. 3/10/2000.
3/10/2023.
That is, there is no mention.
In the read petition.
Ah.
It is there.
Prayer 1 is nomination paper. These are private papers.
Oh, my lord, yes, my lord.
These are private papers.
Yes, my dear.
Nomination paper.
Yes, my lord, yes.
You are
Sorry, my lord.
you are required to challenge this
Yes, my lord.
this
Sorry.
order only.
It is missing, my lord, sorry.
Step by step, it is very difficult, Mr.
Sorry,
Sinha.
sorry, sorry. But in the title which
indicated-
I have given, title which I have given, madam.
Huh?
In the cost title I have mentioned, madam. Sorry, the prayer it is missing.
Prayer is missing.
Yes, madam. Cost title I have mentioned, arbitrary and illegal order.
The order not challenged cannot be set aside also.
My lord, I have mentioned in the cost title mentioned. Here the,
You are running a risk
madam, yeah, madam, I will affidavit
to
subtract.
inter alia
That the
challenge nomination papers submitted by the proposed party respondents for contesting the election to the Board of Directors of Messrs. Sunaburi Hat Cooperative Society Limited, a society registered under the provisions of the Cooperative Society, Assam Cooperative Societies Act, 2007 as amended. Full stop. The instant interlocutory application has been preferred by the applicant's petitioner seeking implement of the said 15 number of persons whose whose nomination papers have been challenged in the connected writ petition. First up, it has been stated and averred that the presence of those 5 persons as party respondents in the connected writ petition is necessary for the purpose of adjudicating the issues raised in the connected writ petition. First up, Mr. Raskwal and counsel, sending counsel, Cooperation Department appearing for the opposite party number so and so has submitted that in view of the nature of issue involved in the connected writ petition, he is not objecting to the prayer made in this interlocutory application. First up, in view of the nature of grievance, raised by the applicants as writ petitioners in the connected writ petition, and for the facts briefly narrated above, this court is of the view that presence of the proposed party respondent proposed the as party respondent number as indicated as opposite party number 7 to 21, as party respondent number 7 to party respondent number 21 in the connected writ petition is allowed, the office to cause necessary correction in the cause title of the connected writ petition on filing of an amended cause title by the Planning Council for the petitioner by tomorrow and release the case Friday. We'll try on Friday.
I have appeared for some of the.
First of Mr. M.J. Qadir. By the time your caveat will be listed.
But by requisition, my lord, I had got my lord.
Mr. M.J. Qadir, Learned Counsel has submitted that a caveat has been filed.
My lord, it is brought on
Has already been filed. White caveat number.
It is brought on record, my lord, today by requisition. He has filed today only.
Caveat number to caveat number to file over. Caveat number 1399/2022. Office to release the case, the caveat along with the repetition on Friday. Right.
Time being item numbers 5 and 6.
Yes.
My lord, in view of this submission made by the council for the, my lord, pharmacist council, that the approval that has been granted by the, my lord, government has been
Our motion
withdrawn.
আছে নেকি? Our motion আছে নেকি? হ্যাঁ? এরপর কিরকম কিটা আছে? আপনার একটু টাইম লাগবে না? এই রকি থাকিব। হ্যাঁ? 5-6 to বাদ দিয়ে আৰু Council for 9, 10, 11 are available.
Yes, my lord, I have for 9.
Oh, missed it. Otherwise, they will be waiting. Huh.
Item number 9.
Yes, Mr. Deuri. What is the case?
Sorry, my lord.
Yes. He is ahead of you. Yes. What is your case?
Your Lordship, in this case, I had filed an RTI application. Your Lordship may kindly peruse page 24.
So, alleging irregularities
Yes, Your Lordship.
in the selection of beneficiaries.
Yes, Your Lordship. They
That
have
is
not
all.
provided anything. The RTI application is filed, appeal has been filed.
And non-furnishing of replies.
Yes, Your Lordship. nothing.
Okay, we will issue notice at this stage. Heard Mr. T. Deori. Learned counsel for the petitioner. And respondent,
Lordship,
Mr.
U Sharma on behalf of MS N Bora.
N. Bora. N. Bora, he is but.
For
Standing counsel?
respondents 2, 5,
Huh?
6, 7, 8, 9.
N. Bora, MS N. Bora, Standing Council Panchayat and Rural Development Department for the respondent number
2, 5, 6, 7,
5, 6, 7,
8, 9, and 10.
8, 9, and 10. As Burwa likhibo agote. CGC? Any CGC? You are CGC?
Respondent number 1,
MS,
on behalf of Rita Devi. Rita Devi.
RDB. Your name?
Dipsika Chaudhary.
D.
Chaudhary.
Chaudhary. Kibo? Or Mr. S. Burwa. My junior government pocket Assam for the respondent number 4. First. Alleging the petitioner has alleged that irregularities, stroke illegalities have been committed by the respondent number 6.
Yes, sir.
By the respondent authorities in the Panchayat and Rural Development Department, more particularly, the respondent number 6 in selection of beneficiaries of what scheme? What scheme?
Pradhan Mantri Awas Yojana, Your Lordship.
Pradhan Mantri Awas Yojana, PMAY. Which area?
This is with
In connection with Saniadi, Borni, Bongalpara, Gaon Panchayat, under Haju Development Block. First of the petition has further alleged that despite seeking information under the Right to Information Act 2005, the respondent authorities have been dilly-dallying in providing the information the petition has sought as regards the selection of beneficiaries, right?
Yes, sir.
Issue notice returnable in 4 weeks as so and so appeared accepted. No formal notice. I think every respondent is represented.
Yes, Your Lordship.
Okay. No formal notice, extra copy is into working this.
Item number 10.
Then is similar, Your Lordship. Only thing is that they have provided half the information to me, only a part of the information.
Okay, this is only right to information.
Right, this is
Okay.
we just
Third, Mr. T. Theory, learned counsel for the petitioner.
this is with MG Nrega scheme, Your Lordship.
D. Chaudhary, 1.
U Sharma on behalf.
Sharma, U. Sharma, 2,
2, 5, 6,
5,
and 7.
6, 7. S. Burwa, 4 only. What about 1, 3, 3? There is standing counsel.
No. No.
The petitioner has instituted the instant writ petition. Agreed by the action on the part of the respondent authorities, more particularly, the respondent of 7th. In utilizing the funds under the Mahatma Gandhi National Rural Employment Guarantee Scheme during the period from 2018 to 2019 to the year 2020 to 2021 in respect of Saniadi Gaon Panchayat Haju Development Block. Then why you have made respondent number 3 a party?
Respondent number 3, Your Lordship, was the person who gave the direction for the information, but no direction information was provided to me. That is why.
So for Gaon Panchayat, you want CBI investigation?
Because there are allegations, Your Lordship, that they have misappropriated the funds.
So you want CBI investigation?
Yes, your lordship, if, you don't- let them file and reply, your lordship, because they have not.
Have you
provided-
filed anything? Any FIR?
No, your lordship.
So you directly ask for CBI investigation?
No, no. Only the information. your
Huh?
lordship.
Without filing any FIR, you have directly asked for a CBI investigation. That appears to be a bit lofty. As so and so appeared accepted notice. Huh? Extra copies which involve in this. Why you have made respondent number 3 a party?
It was his direction, your lordship. They should have provided me the information. but
Huh?
They have not provided me the information.
1 minute.
The State Chief Information Commissioner directed that the information will be provided to me, but no information was provided, your lordship. Only partial information was provided.
Your prayer runs from page 20 to 22.
Your lordship.
No relief has been sought against respondent number.
Yes, your lordship. I have not sought any relief. I have just
So-
made him a party because.
No,
I
no,
thought-
no, we don't. If he is not involved anywhere, why should having regard to the statement and affirmance made in the writ petition and the prayer made in the writ petition, this court does not find any necessity to issue any notice to the respondent party respondent number 3 at this stage. Extra.
Item number 11.
Item number 14, may I just one word I will put on. I will just start the prayer, only one word.
You are, Mr. Sinha, you are
Sorry, my lord, because for that, only one
making several corrections from time to time.
word. Only one correction, only one in the prayer. I will allow. Right.
40.
Item number 14.
Too many. Yes.
11.
May please lordship. My lord, here are 32 petitioners before our lordship. And against them, my lord, the government of Assam has allotted certain portion of land. Lordship may kindly see page 29. Here, elaborate discussion regarding the land is not mentioned, but it is coming later on. It is in page 52. Now, Lordship would say here 32 persons, 1 biga per family to 32 deserving river eroded families for house, stay, purpose and land in sewer in lieu of agricultural purpose by 32 families may be allowed along with 59 original allottees. So now 59 original allottees, Lordship, that would kindly see page 31. Page 31, with reference to the above, I am directed to convey the sanction of government of Assam to de-reservation of land measuring 240 bigas from Ghugubari village grazing reserve of Rupshi Mauza for rehabilitation of river eroded people, 59 families. So this 59 plus 32, that is 91 families, they were allotted 240 bigas of land. And our lists were also prepared, by the way. That list, Lordship may kindly see page 65. First, Lordship would see that is family. Sorry, my lord, page 52 kindly see. Page 52, 65 is next thing. 52 kindly see. Here, the circle officer demarcated the land and handed over possession to us. And the circle officer also prepared a list. That list may be seen at page 57. This 32 people's list. So these 32 people will get some patta of this land. Now government has allotted and handed over the possession of this land to us, measuring 106 bighas, which is our share. But patta is not granted. So we have filed petition before the authority, and authority till today has not taken any step to issuance of patta.
So you claim that this 32 number of families,
Yes,
of which the petitioners are members,
yes,
were allotted plots of land
yes.
measuring 1 bigha each.
For house estate. And the rest of the land shall be shared by 59 families plus 32, that is 92 families.
How many bighas?
The total land is 240 bighas.
No. How much? 232 families.
No, 32 plus 59, 91 families.
32 plus 59, 240 bigha.
It- 240 bighas.
Mr. Borua?
So, my lord, one thing is there is pending another case by this 59 people have filed a petition. And that in that case, we are not met parties intentionally. So that case is fixed on 3/1/2024.
You want issuance of notice or fixing it on
The
31?
notice may be kindly issued.
Then
on-
it will go in the last part of January. You want it to be listed on 3/1? Choice is yours.
The Lordship kindly fix it 3/1.
In the motion column.
Yes, along with WPC number.
No, that is already the order. Mr. M.U. Mahmood, learned counsel for the petitioners, has submitted that another petition. WBC number
3550/2020 filed by the private respondent.
related to the issues involved in this petition, has been ordered to be listed on 3/1/2023. In such view of the matter, he has sought for listing of the instant writ petition on 3/1/2023, 4 to 2024. As sought for by the learned counsel for the petitioners, list the case in the motion column on 3/1/2023. I think that will be better.
Yes, I will. I love it.
Item number 12.
12. Yes. Yes.
May I please, your lordship? Lord, the land of the petitioners, my lord, were acquired, my lord. And for, my lord, widening the road, my lord. And the government, my lord, deputy commissioner, my lord, issued notice to us, my lord, to, my lord, deposit our required documents, my lord, page 25. Page 20 onwards, my lord. Accordingly, my lord, we appeared. We, my lord, furnished all the documents, including our bank account, my lord. And thereafter, my lord, the compensation has been, my lord, not paid to the petitioner. And the respondent number 4, my lord, all the compensation has been, my lord, deposited in his account, my lord, without our knowledge. Then we file an application before the deputy commissioner, my lord, page 49.
Money is gone already.
Money has already been deposited in the
Private account.
Yes, my lord. Then we file a complaint, my lord, page 49. Thereafter, my lord, the respondent of 4, my lord, he made some, my lord, partial payment, and rest, my lord, is still in his account. And without, my lord,
We cannot stop from operating. We cannot put a stop in that private account.
So, my lord, the deputy
We
commissioner-
cannot stop defreeze that private account of respondent.
regarding the
We
compensation
can issue
amount, my
notice
lord,
at this stage. They are relation.
lordship,
Who?
co-partners, my lord.
Patadars,
Co-partners.
Alimuddin. Let us see. Alimuddin, Nazimuddin, son of Abdul Haq. and Tajuddin Abdul Bari.
Lordship.
Is there any relation?
No,
Blood relation?
he's co-partner, my lord.
Co-partner.
Lordship.
So it is not that
In the first notice, my lord,
your participation was excluded.
and my lord, in case
You were
25,
put
my
on
lord.
notice, you participated thereafter. A disbursement was made in his paper.
My lord, although, my lord, in page 25, 3 plots, my lord. Individual plots is also there, my lord, and individual notice was also given to us. Page 25.
So award has been passed already. Disbursement has been made.
Lordship.
Did you file any application?
We filed application before the deputy commissioner, my lord.
Then
Page-
only thing that he can do is that refer the matter to the principal civil court of original jurisdiction.
Page
of the district.
55, my lord.
Only that thing is available. Disbursement is also made. He has discharged his part. Rightly or wrongly disbursed
My lord,
the
the-
amount.
my lord, the
It is deposited in the private account of the respondent number 4.
lordship, although, my lord, the award ought to have been, my lord, individually distributed to the,
Right.
as per, my lord.
What is the next course of action for you?
Now, deputy commissioner may, my lord, make inquiry, my lord, regarding the disbursement.
Or otherwise entitlement is to be decided by the principal civil court. You have made the application.
The deputy commissioner, my lord, he can also, my lord,
Can issue notice at this stage. Hard.
he can refer the matter for,
On the that is on the next day. Only thing he can refer if there is some dispute. Hard, Mr. R. Ali, Learned Counsel for the petition. Petitioners, A. Bhattacharya. Yes, tell me.
Yes, in fact, civil court will decide as regard the apportionment because ultimately the deputy commissioner will be entrusted with the responsibility of shifting it off. So,
So, A. Bhattacharya, respondent number standing counsel 1, revenue. S. Borua,
2, 3.
2 and 3. Poster. Agree by the disbursement
Apportionment.
of the entire compensation amount in favor of the respondent number 4 by the respondent number
2, my lord, deputy commissioner.
2 in respect of land acquired under the project development and construction of widening of existing roads from Tumprang Bridge to Howrah Ghat under Assam Mala project, the petitioners have preferred the present petition. So it is the case of the petitioner that they are the recorded patadars in respect of dag number
364, 365, and 98.
364, 365,
988.
988. Under pata number
167.
167, located at Revenue Village, Sabaspur, Moja, Nomati. Issue notice returnable on as Mr. Borua, Bhattacharya, no formal notice, extra copies within 2 working days. The petitioner shall take steps for service of notice upon the respondent number 4 by registered post with AD within 2 working days.
Lordship, our name may be shown in the cause.
The name of Standing Counsel Revenue Department be reflected in the respondent side in the cause list.
My lord, pendency shall not bar to consider our representation, page 55.
For what?
It is pending.
It is observed that the pendency of the petition shall not be a bar for the respondent authorities to consider the representation dated
18/9/2023.
18/9/2023 stated to have been filed by the petitioners. Obliged. On its own merit, I 5-6. Are the motion nine?
My lord, my lord, in page, my lord, 39, 41, 44, type copy, my lord, this slight correction, my lord, is there, my lord. In place of our name, was written as, my lord, additional deputy commissioner.
The
Type
learned
copy,
counsel for the petitioners is permitted to cause
39, 41 and 44.
as paid for to cause necessary correction. At page number
39, 41, 44. In type copy,
before
my lord.
the registrar judicial
Clause.
in his own handwriting before the registrar.
Obliged.
Yes.
5 and 6.
Before my learned friend begins, well, I'll just say, my lord, this petition is, your lordship, because the impugn order is, government has allowed us to. do
I
the
have not
election.
looked into any single paper till now.
No, I'm just saying, my lord, government has allowed, there are other issues are there, but other issues are gone, only issue which is survived is. My lord, whether, my lord, to continue the election by digital mode or by ballot paper, postal ballot. The government has permitted, my lord, earlier for going to adopt this digital mode. This has been withdrawn now. So therefore, in view of that, my lord, we will have to, it has become interest cost and we'll do the election within a period of 3 months. Yes.
Nothing survives.
Nothing survives.
You could have said then, then I would not have saved time for this.
My lord, I have given a bunch, my lord.
What to record then? I have not looked into any paper. I thought that I'll hear you out.
My lord,
They'll
in
hold
view
the
of
election as per the
in view of
provisions.
the government order, my lord, dated so and so, my lord.
Okay, first let me proceed. I heard Mr. PJ Paikia, Learned Senior Counsel. Learned Senior Counsel, assisted by Mr.
KJ
KJ Soikia. Learned Counsel for the petitioner in 5.
In WPC
Mr. AJ Das. Learned Counsel for the petitioner in 6. Also heard Mr. B. Gogoi, Learned Standing Counsel, Health and Family Welfare Department. For the state respondents, Mr. B.D. Das, you are for?
For 5, I think, my lord.
Register.
4, 5 and 6.
Yes,
4,
my
5, 6.
Okay. In the first state petition, Mr. Gogoi, you are for 1 and 2.
1, 2.
1 and
3,
2.
my lord. Council,
Huh?
5 and 6, my lord.
Okay. 1 and 2, Mr. Gogoi, in item 5, right?
my lord. 1 and 2 and 3 also, my lord. Other
Or
council,
3.
yes.
3. And for the respondent number, okay, 1, 2, and 3 in both the writ petitions. And Mr. B.D. Das, Learned Senior Counsel, assisted by Mr.
HR
Sharma
Das.
Das, Learned Counsel for the respondent number 4. Sorry. Huh? No, in the first writ petition, register. You are for register.
For the returning officer and Mr. Deka, my lord.
Okay.
President come returning officer.
Then Gogoi is for register.
Yes.
Okay. 1 to 4 in both the writ petitions. And Mr. B.D. Das, Learned Senior Counsel, assisted by so and so, for the respondent number 5 and 6 in item 5, and for the respondent number 5 in item 6. উল্টা হৈছে কোনখন আগত আছে কোনখন আছে আগত উল্টা হৈছে দেই PJ Soikia item 6 AJ Das item 5. Okay, which was challenged here?
In view of the my lord, order, your lordship will condition Mr. Gogoi has submitted. In view of that, my lord, the petition has become infructuous and the council will hold the election within a period of 3 months.
Okay. The 2 writ petitions both the repetitions have been preferred. Assailing,
Saying the permission granted by the
assailing
government.
and permission granted by the returning
By the government, madam.
by the state,
State, yes. To adopt the.
by the Health and Family Welfare Department.
Yes, sir.
Health and Family Welfare Department to conduct the election for constitution of
For 6 members of the state
okay,
council. madam.
to conduct the election. Where is the notification?
Page 44. Page 44 of 2190.
The PJ Soikia's petition. That notification.
Yes, madam.
Okay.
We have challenged that.
He will find it, my lord.
Mr. Das, you have also challenged this.
Same.
Have assailed a notification dated 10/2/2023. Published. This is MC Dhaka President.
Yes.
Issued under the hand of the President cum returning officer, Assam Pharmacy Council, and published in the Assam Gazette in its issue dated 13/2/2023. The primary ground of challenge was that
Without the amendment of the rules, my lord, which my lord provides my lord holding of the election by ballot.
where is it online? Online part?
Online, my lord, last third line of first para. In page 44. Last third line, page 44 of the first.
To elect 6 number of members to the Assam Pharmacy Council under clause small a bracket of section 19 of the Pharmacy Act 1948. Full stop. As per the said notification, the said election was contemplated to be conducted using digital mode of system within bracket online voting system. Full stop. The primary ground of challenge in both the repetition is that there is a set of rules named
Assam Pharmacy Council Election Rules 1959.
Set of rules. Assam name VIJ.
You will find the rules at page 28 of the band.
Yes, 28. Yes, 28 of what?
Of that band side, that's not.
Oh, bunch. Okay. What is the name?
It's a long name. my lord. The rules for election of members, my lord, the rules for election of members, including the president and vice president of the Assam
Okay.
Panchayat Council.
Okay.
And the members
VIJ
of the
rules
executive.
for the election of members, including the president and the vice president of the Assam Pharmacy Council and of the members of the executive committee of the state council. Unquote.
And the relevant will be, my lord, page 30, rule number 8.
1 minute. Have not contemplated any election by digital mode. And as such, comma, the decision to conduct the election without amendment in the said rules is not permissible. Full stop. That's all?
The government has earlier directed Malab for holding the election on the basis of as per digital mode. That has been withdrawn. That
Now
was-
I will record.
Yes, that is what is important. Government has withdrawn, man. The controversy is whether the government had power or not.
No,
So
the
that is-
controversy was
now it is
whether
gone.
the
Now it is-
council had the power or not. Approval came subsequently. Now since they are.
It has been,
we are not going to the
it
controversy.
has been submitted at the bar. Mr. Gugoi and Standing Council, Health and Family Welfare Department has placed a letter bearing number so dated 27/10/2023 of the Health and Family Welfare Department, Government of Assam, to submit that.
My lord, this letter, my lord, 22/3/23 is at page 9 of the bar.
Page 9.
9, that is the approval. It is good.
Page 9.
No, offense approval. No, because-
That is the first approval letter.
Okay. Technical equipment. No, by which the approval earlier granted by the state government to the Assam Pharmacy Council's proposal dated 8/2/2023 to conduct the Assam election to the Assam Pharmacy Council by digital mode within bracket online voting system has been withdrawn. That's all. Full stop. As the
No, I'm giving undertaking on behalf of respondent of 5 and 6. That it will be done, ballot papers
Okay.
within a period of
Mr.
3 months.
Bididas Lanet, Senior Counsel, appearing for the
Respondent of 5 and
returning.
6.
Appearing for the President cum returning officer, Assam Pharmacy Council, Directorate of Health Service, like Assam Pharmacy Council, Assam, has submitted that the election for the Assam Pharmacy Council
6 members.
election to the 6 members. Six members under what?
Under section
Section 19 of the Pharmacy Act.
Under
19
section
within bracket-
19,
19 within bracket small a.
small a of the Assam Pharmacy
No, the Pharmacy Act 1940.
of the to the Assam Pharmacy Council under section 19 small a of the Pharmacy Act
1940.
for the 6 members in the Assam Pharmacy Council is going to be conducted through ballot system,
As provided under.
paper ballot system,
Yeah.
paper ballot system.
As provided under the rules. As provided under the.
In conformity with the
Rules.
extant rules, EXTANT, extant rules. In view of such fact situation, comma, the learned counsel for the parties have conjointly submitted that since the election for the sixth number of so and so are going to be conducted through paper ballot system. There is no cause of action to pursue the two petitions.
By issuing necessary notification.
In view of, within a period of 6 months, sorry, 3 months.
3 months.
বিধি দপ্তর লিখে দিব।
He was
In
saying
view of-
that it will need 4
In
months.
view of above submissions consensus arrived at the bar, these two petitions are closed up.
Providing my lord, we will hold the election within 6 months or 3 months.
Reserving the liberty to the petitioners, to the parties, to avail appropriate remedy in the event of subsequent cause of action. That's all.
Deeply.
I thought that I am going to hear these two repetitions. That is why I deferred it. Mr. Gogoi, shall I keep this? Okay. The documents, including the communication bearing number so and so, dated so and so, placed by Mr. Gogoi, standing counsel so and so, are to be kept as part of the case.
Order implement item number 14.
May I please your lordship?
Yes.
Lordship, in this matter, I am appearing for writ petitioner.
For
Writ petitioner.
read petition.
Lordship, my senior colleague is not well, lordship. So matter.
Who is your senior colleague?
As Bunny.
S. Bonnie.
Yes, lordship.
My lord, we file an IA number 3651 for implement, my lord. My lord,
So what is your submission?
Lordship, adjourn for the day.
Adjourn for the day.
my lord, implement nothing prejudicial cost to them. My lord.
We have
It may
not
be
received,
part-
lordship. I copy.
Oh, you have not
With hearing.
received. Please furnish a copy then. That is another submission.
Yes, my lord.
Copy of the IA has not been received by them,
Yes, my lord. The copy.
being a read petitioner. Yes, Mr. Talukdar. Since Mr. Bonnie is not available, copy is not furnished. Okay.
He is entitled to a copy, my lord.
Heard Mr. A.R. Sigdar, learned counsel for the applicant. MS
At Begum.
M. Begum, learned counsel for the opposite party, the street petitioner, and Mr. S.K. Talukdar, learned standing counsel, Cooperation Department. Full stop. It is submitted by M.S. Begum that a copy of the interlocutory application has not been received by the applicant, the street petitioner.
My lord, just how we have submitted.
Mr. In view of such submission, Mr. Sigdar, learned counsel for the applicant, has supplied a copy of the interlocutory application to M.S. Begum. Full stop. As sought for by M.S. Begum, lays the case on
My lord, in the next week, my lord.
next week, means New Year.
After vacation.
Okay,
Lordship,
5-1,
interim is there.
My lord,
5-1.
Interim is there, lord.
Interim. Required. Not required, I think. Not required. I have passed the order only on IA.
my lord.
15. Item number 15 for admission.
May I please, your lordship?
Petitioner.
Only limited pair is that, lordship, allow the petitioner to deposit the premium of the value fixed by the respondent authority, lordship.
What is impugn?
Lordship, page 45, lordship. Annexa K, lordship.
40.
45, lordship, page. Annexa K, lordship.
Where is the original? Page 47.
Yes, lordship.
I prefer to read the original. Seen the prayer petition. Onima. Sibsagar town.
Yes, Lordship.
Regarding settlement of land measuring 15 lessons. 50 students also seen a proposal for settlement 15 lessons. Government doc in favor of the which was placed in the held on train. Committee approved. Accordingly, proposal was sent for approval. It is noted as per record. It is on petition. One kata 15 lesson.
No, Lordship, 15 lesser, Lordship only.
Huh?
Only 15 lesser, Lordship.
Already owner.
Already I
One
see,
kata 15 lesson.
Lordship, no Lordship, only for 15 lesser, Lordship. Earlier occasions,
So, allotment is, you are seeking allotment of 15 lesson.
yes, Lordship,
But Deputy Commissioner is saying,
Lordship.
you are already an owner of Miyadi Patta land measuring 1 katha 5 lesa Sibsagar town Nagor Mahal Mauja dag number 5028.
Yes, Lordship.
PP Patta number 3083.
Yes, Lordship. It is
Correct or not
admitted
correct?
fact. Admitted fact, Lordship. It is.
Admitted.
Yes,
Then
Lordship.
come, let us see the land policy. Land
Lordship,
policy. When did the new land policy came into?
2019.
19 what date?
Lordship, 1.3 Lordship. It is revealed that
Which land policy, new land policy came when? 2018 or? Huh?
2019 Lordship.
Huh. When it came?
1.3, it is revealed that Lordship.
Land policy,
এইখন দিব এইখন সেউজীয়া আৰু পুৰণিখন দিব This new land policy came in 2019 on what date?
13th November, I think, my lord.
Then this is under 1989 policy.
My lord. Even then, my lord, this
I-
case,
Whether a owner of a patta land in town is eligible to seek allotment or settlement.
in fact, my lord, the real state of affairs that has not been disclosed before lordship by the petitioner, my lord. The father-in-law of the petitioner, my lord, occupied more than 2 kathas of land, 2 katha 10 lesa, my lord. Ultimately, on the application of the petitioner, on the said plot of land, authority allotted 1 katha 5 lesas. Thereafter, again, they are also not landless people, my lord. This is a township within, my lord, this is within the township, my lord, Sibsagar township, my lord. Again, they are seeking, my lord, this portion of land, and now what they have referred to, the deputy commissioner has already rejected that process, my lord. So once the allotment of land considered, my lord, 1 katha 5 lesser, there is no point of considering afresh.
Yes. No, eligibility is defined in
Maximum 1 katha 10 lesser, maximum. But considering the twice, my lord, that question doesn't come.
Lordship, as per Lordship.
urban area.
Yes.
Urban area.
Yes. 1 katha, maximum 1 katha 10 lesser with certain condition.
Earlier
12 to
occasion,
15.
earlier occasion, Lordship, petitioner approached before this court by filing a writ petition, Lordship. WBC number 5731, Lordship, all 2013, Lordship. In view of the said order, Lordship, respondent authority had been allotted 15 lesser land in favor of the petitioner, Lordship.
That process has been cancelled. Lordship will find 14.4, 19 points.
14.4. .3 is not applicable.
Will consider settlement of government in Guwahati, my lord, city and other towns.
In any other town.
Yeah, on the irrespective of period of occurrence, so. But the area of land that can be allotted, that is 14 point.
That is different. But
Yes.
eligibility.
My lord.
Eligibility is that an indigenous person.
Yes.
Who has no land in his name.
Absolutely.
And in the name of any member of his family.
Yes.
And who has been in occupation of the government land, which members of his family for last 15 years, twin conditions.
My lord.
That the indigenous person should not have any land in his name. Because you are depriving some other indigenous eligible person.
Lordship, I am not,
Only after
our side is
coming-
not mistake, Lordship.
Only after the petitioner, only after coming to the land of my lord father-in-law.
Let us
Simply-
see, the statement, let us see the statement of the state
Yes.
in the affidavit.
My lord. Paragraph 4, my lord.
Paragraph 4.
Yes. 5.
He has already allotted. He has already been allotted. 1 katha, 5 lesson.
5 lesson.
So sale has been handed over. Running a hotel.
This
You are Toroni.
Yes, Lordship. Already land advisory board also had been allotted, Lordship, and
They are
premium
not
is
the
also
final
fixed,
authority.
yes.
That has to be tested on the basis of a land policy.
Lordship.
Eligibility.
Lordship.
And if it is an admitted fact that you have land measuring 1 katha 5 lessa in town,
Lordship.
meaning thereby you are ineligible to be considered for settlement.
And after
Lordship,
allotment
land
of this-
advisory board had been recommended as per High Court order,
Come
Lordship.
to say, make submission on the basis of a land policy. You are eligibility, you are ineligible. We cannot perpetuate
Lordship.
illegality. And it is an admitted fact. Let us see your reply.
Paragraph 5, Lordship.
Clear admission.
Lordship.
No doubt about it.
No, Lordship. Paragraph 4 also I have stated, Lordship.
And that is in 1998.
Lordship.
1998.
Yes, Lordship.
That you are quite ineligible. We cannot interfere with this order. Impugn order, we cannot.
Lordship.
Yes, anything. Mr. Mr. Boswell, you are.
Lordship, already land advisory committee had been approved, Lordship.
We'll deal with that.
Lordship,
that
Lordship.
process already been interfered with. That process has already been cancelled, rejected.
Only for time board, Lordship, not only cancelled.
Whatever it may be.
Where is that order?
Lordship, Annexa K, Lordship, 47, Lordship. Which have been also read, your Lordship.
40?
47, Lordship.
7.
Last line also do hereby reject and proposal as time board, Lordship. Last line, Lordship.
It is an admitted fact that as per the report.
Lordship, as per High Court order.
Let us see High Court order.
High Court order,
High
Lordship.
Court order, let us see.
Lordship.
Examine this page 34.
Yes, Lordship.
That is not a positive direction.
Lordship, in this regard, Lordship, land advisory, subdivisional advisory board.
Where is that?
Lordship, Annexa D, Lordship.
Page?
Page, Lordship.
After this order, that hasn't.
Lordship,
that has
21,
final
Lordship.
development.
Page, Lordship, 21, Lordship. Type copy, Lordship.
Page 21. Let us see the original.
Original, Lordship. 25, Lordship.
25. Which part?
Shivsagar Avenue, Sagar, Lordship. 3, Lordship.
Shivsagar. Okay. Shivsagar Avenue, serial number.
3, Lordship.
That is half, right?
Yes, Lordship.
Oh, it is half. Then we have to see the
The meeting discussed
type
the
copy.
proposal
Type
for
copy. We have to see
settlement.
the
Tenants
type copy. That
protection.
is half.
Yes, Lordship.
Not
15
fully.
lesser covered by so and so, Lordship.
Measured by so and so approved realization. Then you prefer that writ petition, right?
Yes, Lordship.
And who is the ultimate authority?
Deputy Commissioner, Lordship.
So ultimate authority has rejected your case.
Lordship, he has been speaking order 2019, Lordship. Court has directed the speaking order within a 3 months, Lordship.
So whether that illegally negative plus negative will become positive.
No, Lordship. Lordship, kindly consider it, Lordship. Already respondent authority have been considered all the
Considered, and
circumstances, Lordship.
considering that put a status quo since 2019,
Lordship.
but no longer heard. The present writ petition under Article 226 of the Constitution of India has been preferred by the petitioner to assail a speaking order dated 24/7/2019 passed by the respondent number 3, whereby the petitioner's prayer for settlement of a plot of land measuring 15 lesses, covered by government DAG number 5072, situate at Shivsagar
Town Part 2, Lordship.
Shivsagar Town, Part 2, Mauza, Nagar Mahal District, Shivsagar. Subject law has been rejected. Post. It is the case, I have heard Mr. P.K. Gogoi, learned counsel for the petition, and Mr. B. Goswami, learned additional advocate general, assisted by Mr. R.R. Kakoti, learned counsel for all the respondents. Full stop. The
My learned friend will also be there.
okay, assisted by Mr. R. Barbudari, learned standing counsel, revenue and disaster management department, and Mr. R.R. Kakoti, learned counsel for the respondents. Full stop. The petitioner claims to be an indigenous person. Full stop. A process, it transpires that the petitioner submitted applications. It transfers from the speaking order, impugn speaking order. The petitioner submitted applications, dated 5/11/2015 and 23/11/2015. Before the respondent authorities with a prayer to accord approval to settlement of a plot of land of the subject lot. subject plot question of the subject plot. Full stop. The petitioner has stated that the petitioner had been in possession of since a long period of time. Full stop. The petitioner had earlier approached this court by way of a petition, WPC number 5731/2013. Full stop. While issuing notices to the respondents, this court by an interim order dated 7/10/2013 had directed, had observed, had directed, as an interim measure that possession of the petitioner in respect of a parcel of land measuring 2 kathas, 8 lesas, situated at Ward number 9, Mauja Nagar Mahal, district Sibsagar, should not be disturbed. Full stop. The subject plot is part of the said 2 kathas, 8 lesas.
Yes.
In respect of which the said interim order was passed on 7/10/2013. Full stop. The petitioner preferred a representation before the respondent number, on the basis of Oh, you got the position on the basis of that interim order. On the basis of the application of the petitioner seeking settlement of the subject plot, the circle officer, Sibsagar Revenue Circle, prepared a proposal for allotment stroke settlement of the subject plot. And the said proposal came to be placed before the Subdivisional Land Advisory Committee, Shivasagar Subdivision, in its meeting held on 12/1/2015 under the chairmanship of the Deputy Commissioner, Shivasagar, being the chairman of the Subdivisional Land Advisory Committee, Sibsagar Subdivision. The SDLAC discussed the proposal for settlement of the subject plot in favor of the petitioners and had thereafter, approved the same, subject to realization of due premium. Full stop. When the proposal regarding allotment of settlement of the subject plot in favor of the petitioner was found to have been not considered alleging that the proposal for settlement of the subject plot in favor of the petitioner was not considered in an with due earnestness the petitioner preferred another writ petition, WBC number 5731/2023. Full stop. It was observed as it was the writ petition was disposed of by an order dated 22/04/2015. Observing inter alia to the effect that whether the public particular land should be allotted to the petitioner was a matter to be decided by the appropriate department of the government, state government. Full stop. Having regard to the nature of the grievance raised, the writ petition was disposed of by directing the state respondents to examine the feasibility or otherwise of the case of the petitioner for settlement of the subject land and after taking such decision, to communicate the decision to the petitioner. Full stop. After disposal of the writ petition, WBC number 5731/2023, by order dated 22/4/2015, a proposal was forwarded from the Circle Officer Sivasagar Revenue Circle to the Deputy Commissioner Hibahagar on 15/6/2015, indicating the premium amount that was required to be collected in the event of settlement of the subject plot in favor of the petitioner. Full stop. The proposal was thereafter, the proposal to settle the subject plot was thereafter forwarded to the Revenue and Disaster Management Department from the Office of the Deputy Commissioner on 26/2015, and the Revenue and Disaster Management Department had in turn wrote to the Deputy Commissioner Hibahagar on 4/11/2015 to abide the direction made in the order dated 22/4/2015, passed in the writ petition WPC number 5731/2013. Where it was thereafter, the impugned speaking order came to be passed on 24/7/2019. Full stop. The main ground on which the proposal for settlement of the subject plot in favor of the petitioner has been rejected is that the petitioner has a plot of Miyadi Patta land measuring 1 katha 5 lesa.
My lord, may I clarify to that? The government DAG number was, the entire DAG number was 5072 at Sibsagar town, my lord. Against that 5072 DAG number, my lord, new drug was created, that is 3208 out of the seat 2 katha 8 lessons, my lord. 1 katha 5 lessa was allotted to the petitioner.
Yadi Patalan measuring
Yes.
1
we
kata
had-
5 lessa at
yes.
Sipsagar town, Mauja
Yes,
Nagar
but
Mall.
Originally, it was a government land. 1 katha 5 lessa was allotted and created a new drug, and this has become, my lord, Miyadi.
Pusto. It has been clarified by the Land Council for the parties that the petitioner sought allotment of 15 litres of land out of government DAG number 5072. Full stop.
Where from already 1 katha 5 lessa has been allotted.
Full stop. Fair. From the counter affidavit of the respondent number 3, in the counter affidavit of the respondent number 3, comma, it has been averred. It has been categorically asserted that the petitioner has already been allotted a plot of land measuring 1 katha 5 lessa under new DAG number 3083 and periodic patta number 3083 within bracket carved out of original government DAG number 5072 bracket close and periodic patta number 3208 at Sipsagar town, Mauja Nagar Mall. And accordingly, comma, possession of the said plot of land measuring 1 katha 5 lessa was already handed over to the petitioner. Full stop. It has been further averred that the petitioner, after taking possession of the land settled in her favor, has been in possession of the said plot of land measuring 1 katha 5 lessa, and she has been running a hotel therefrom. It has been asserted that after allotment of 1 katha 5 lessa, after settlement of 1 katha 5 lessa, in her favor, comma, the petitioner had again applied for settlement of the subject plot measuring 5 lessas. 15 lessas. Full stop. It has been further stated that the petitioner was in unauthorized occupation of the subject land since long. Full stop. In view of such categorical assertion from the state respondents, comma, it appears it is also apposite to find out the stand of the petitioner in the affidavit in reply. Full stop. In the affidavit in reply, the petitioner has admitted that a plot of land measuring 1 kata 5 lesa at Sipsagar Town Part 2, Nagar Mauja, has already been allotted in favor of the petitioner by carving out a new DAG number 3083 under periodic patta number 3208. Full stop. It has also been admitted by the petitioner that the said settlement has been made in favor of the petitioner on 20/05/1998. Full stop. The matters of allotment, stroke settlement of land, that's both rural and urban, are considered in terms of the land policies framed by the government of Assam from time to time. Full stop. At the time of passing the impugn order dated 24/7/2019, the prevailing land policy was the land policy of 1989. Full stop. Clause 14. Yes. Of the land policy 1989 has provided for settlement and reservation of land in towns. Full stop. As per clause 14.3 are of import and relevance for the purpose of the case in hand, and the same. And the contents of clause 14.3 are extracted herein in extenso 14.3. As per subclause 1 of clause 14.3, an indigenous person to be eligible for settlement of any plot of land in a town has to meet the twin conditions of eligibility, firstly, such person shall have no land in his name or in the name of any member of his or her family. And secondly, such person shall be in occupation of government land with the members of his family for last 15 years or more. Full stop. Though it is claimed that the petitioner has fulfilled the second condition of eligibility, comma, the petitioner is found eligible in view of the fact that the petitioner has already been settled with a plot of land measuring 1 kata 15 lassa in the year 1998.
1 kata 5 lesser.
1 kata 5 lassa. And as such, the petitioner is not an indigenous person who has no land in her name. Full stop. As the petitioner is found to have not fulfilled the twin conditions of eligibility under subclause 1 of clause 14.3, comma, this court does not find any merit in the contention of the petitioner, that does not find any good and sufficient reason to interfere with the impugned order dated 24/7/2019, passed by the Deputy Commissioner Sibsagar as the competent authority to take the final decision as regards the matter of settlement. As the writ petition is found not merited, the same is accordingly dismissed. There shall, however, the interim order passed earlier stands recalled. There shall, however, be no order as to cost. Anything to be added?
Production list, item number 1 for motion.
Wait, please.
Yes, sir, Mr. Borpujari, whether he is a party.
Well, the state is a party, my lord.
State is a party.
But as Boda was also there. I'll call him.
Have you served any copy?
Yes, my lord, it was start the sending council, my lord. My colleague is calling him, my lord. Lordship may kindly turn to page. Lordship will turn to page 18. It's a copy of a page 17. In fact, it starts, my lord. It's a registered sale deed. By way of this registered sale deed, the petitioner number 1 and 2, they are husband and wife, my lord. They purchased 2 plots of land. One, a flat of measuring dot schedule, lordship will kindly come to page 26, my lord, of the sale deed.
No, this is for the purpose of sale of plot of land or apartment.
A sale and a flat of 1340 square feet and an open space of 144 square feet at the terrace. That schedule is at 26, my lord, page 26.
This is residential flat.
And a floor and measuring 144 square feet open shed in the 6th floor at block 2.
Which one? Page 26.
Page
Schedule
26.
B.
Page
Schedule
26,
B or what?
Schedule B, Schedule B, my lord.
Flat 13 square feet C type in a 2nd floor and measuring open shed in a 6th.
Lordship has got it, my lord. It was purchased by the petitioners from its builder, who is included as respondent number 4 in this petition, my lord.
Now, this flat or this open space?
Open space. Lordship, may kindly turn to page 28 for a moment. That is the sale permission given by the competent authority, my lord. And if your lordship see the schedule, lordship will see flat area with 1484 square feet. That is, if your lordship adds 1340 and 144 square feet, it comes to 1484 square feet, my lord. The competent authority had given sale permission, and copy of the sale permission was in fact marked to the Chief Executive Officer of GMDA. Down below, my lord, it is written at page 28.
Now, you are not out of the flat.
I'm not out of the flat, but
Now
my,
tell me what is the permission?
my lord,
By the
Lordship, will
builder.
turn to page 30, my lord. That was provided to me by my builder.
That is provided to you by the builder is one thing.
Yes, that my lord,
And
Lordship sees.
Permission by the GMD is another thing.
Lordship will kindly see page 30 original, my lord, type copy relevant portion at page 29. Lordship may turn to page 30, my lord.
30.
30, my lord, 30.
30.
For the middle portion, my lord, area statement for proposed building. Lordship has find it. Lordship may kindly turn at serial number 7, 6th floor. 6th floor area, 70.52 square meter. That amounts to, my lord, 759 square feet. And if your lordship sees towards the left-hand side, it was approved by subcommittee, approved Chief Executive Officer, Guwahati Metropolitan Development Authority. They have approved it, my lord. But out of this approved floor area of 759 square feet, the petitioner is inclusive of that 144 square feet, which I placed before your lordship. Is inclusive of that area, my lord, which was permitted by the GMD authorities at the 6th floor. Lordship has got it, my lord. Now, my lord, suddenly, if your lordship turns to page 31, the petitioner was served with a demolition notice on 27/7/2023. And that was the first notice petitioner served. And before receipt of that, my lords, I have made specific statement that no notice was prior served to the petitioners.
No, this is 27/7.
Yes, 27. This is the
That
first.
is quite far from today.
Yes, my lord. Subsequently, they have also issued another, my lord.
One minute, let me read.
Yes. Here, my lord, there is a reference of a case order passed by RERA.
Notice under so-and-so was served, so-and-so which was duly received. Reply fine is carefully examined, careful same is rejected as a failure to furnish any permission against one room with brick wall and
that is the 6th floor.
Yes, that is second paragraph. Please read.
Yes, my lord. Therefore, whereas, my lord, I have not, it was not sent to me, my lord. Some Nivas is different, my lord. What I am stating. This is the first notice. First
Was
notice,
served to Sri Anuj Singh Roy.
I have made a specific statement that it was not served, my lord. In my pleadings, my lord, lordship will kindly turn.
Anuj Singh Roy, where a reply furnishes by Prakriti Nivas.
Lordship may kindly, if it takes a page 6, my lord, in my pleadings, I have specifically stated that no notice was ever served to the petitioners, my lord. It may be served to that welfare society, my lord. Petitioner is not aware. It was not served. Thereafter, my lord, the petitioner came to know that.
1 minute, let me read.
My lord.
So RERA was also.
Yes, lordship, the
involved.
order has been annexed, my lord. I was not a made party, my lord. Page 32, RERA order, my lord. One Utpal Chaudhary that has been included as respondent number 5 in this petition, my lord. And Nabo Kumar Borwa is the builder. So some dispute between a purchaser and the builder took place. An application was filed by Utpal Chaudhary, my lord. The petitioners were not made parties in the RERA case, my lord. Ultimately, my lord, lordship, what finding the RERA said, my lord. Lordship, order starts at page 56.
What complaint he had filed?
Regarding my lord, some allegations that some common area parking was sold to some other persons, not related to the petitioner directly, my lord. In fact, the relief prayed for was also not there. If you look. Finally, my lord, the RERA passed an order. Lordship, operative portion which is concerned to the petitioner is at page 57. Lordship has got it. The paragraph 2 regarding the construction carried out in the roof of the Prakritik Nivas Block 2, GMDSL inquire into the matter thoroughly and take necessary steps in accordance with their finding.
Where you are reading?
My lord, page 57, my lord. It is part of the order direction passed by RERA, my lord. Page 57, that is related to the unauthorized alleged unauthorized construction, my lord. Lordship has got it, my lord. Regarding the construction carried out in the roof of the Prakritik Niwas, Block 2, GMDS shall inquire into the matter thoroughly and take necessary steps in accordance with their finding and Guwahati Building Construction Regulation Bylaws 2014 and shall furnish their action taken report to Assam Real Estate Regulatory Authority in due course. In case the construction is found to be unauthorized, then appropriate steps shall be taken by GMDA to remove the same. So there was a direction to verify and thereafter to take necessary actions. My lord, on receipt of that, my lord, notification that first demolition order, my lord, which was placed before your lordship at page 31, petitioner submitted his representation at page 58, my lord. Lordship has got page 58. Proper spot verification of site and stop demolition work. I have the honor to inform you, a letter has been received by Secretary Prakritik Niwas Welfare Society, if I memo number so, where my name has been mentioned for constructing an unauthorized building on 6th floor of Prakritik Niwas. In this matter, I want to mention that I have purchased a flat in the 2nd floor of Block 2 along with a covered area below the society's water tank measuring 144 square feet on the 6th floor of Prakritik Niwas, Block 2, along with my wife, so. And the said area is, and this is important, far given to the builder of 400 square feet in the 6th floor, which your office has gave NOC number so. And subsequently, my lord, and that I have purchased the sale deed so, which Deputy Commissioner Metro has also given NOC 2007. So already that area, alleged area, is under the, my lord, floor area ratio, which was given to 400 square feet. And that is 144 square feet out of that area, my lord. And as an abandoned portion, on the next page, petitioner also filed an application that even if there is a irregularity, then it can be regularized if any under the provisions of law. My lord, in spite of that, my lord, at page 12, without any spot verification, my lord, that demolition order has been issued. And in fact,
read the MP order.
Whereas a notice under section 88, this is the type copy, my lord, original is at page 62 also. Whereas
original 62.
Lordship. Whereas a notice under section 87, 88 of GMDA Act 1985 was served to Anu Sinha, Prakritik Niwas, 5 GM number dated so, which was duly received. Whereas notice under section 88 GMDA was served to Sri Anup Sinha for removal of unauthorized construction, GMDA dated so. Well, that has been annexed, my lord, 27 first demolition notice, my lord. Whereas letter furnished by Sri Anu Sinha dated 6/11/2023. I have made a statement, my lord, that is not 6/11. It was furnished on 1st of August. It was misplaced by the authority, and on their verbal request, I submitted the same on 6th of November, my lord. Was examined carefully, and after careful examination, same is rejected as he failed to produce any permission against the construction work. Well, permission was already given by the GMDA authorities way back in the year 2012, and which is also apparent from Annexure 2, my lord. And hereby directed to demolish the unauthorized construction. My lord, this notice, although was issued on 12th, I have made a statement that it was served on 14th. It was hanged, my lord. And 5 days would have expired today only. In the meantime, during the, my lord, lunch break today, my lord, I was informed that they have already initiated part of the demolition activities, my lord. Not completely demolished, but as per my instruction. But since, my lord, it was, and if, my lord, that person who has made a complaint, lordship will kindly see that Utpal Chaudhary, he is a resident of Block 1, and I am a resident of Block 2. No resident of Block 1 has filed any complaint before any authority regarding alleging any unauthorized.
That is one matter.
My lord.
That is different thing.
Yes, my lord. But otherwise, my lord, there was a direction from the RERA for verification of the matter, and I have also applied by filing representation for a spot verification. But without paying any attention or any heed to my representation, and without even ignoring their own NOC given, my lord, the respondent authorities could not have proceeded with this, my lord, demolition notice, my lord. Lordship will examine the legality and validity of this demolition notice, my lord. But some protection is required, but that portion is used as his chamber, my lord, by the petitioner at that rooftop.
Yes, Mr. Bora.
My lord, that sale notice is absolutely clear, my lord. He has purchased the open space, not any other space. And that too, an NOC has not been annexed, my lord. Without the NOC, it's difficult to say whether that permission is there.
That with an area of 1484 square feet. And flat is
144 is the open space, my lord.
Open
space, he has covered it with wall and aluminum sheet.
But come to page 30, 6th floor area is 70.52 square meter.
Yes, ma'am.
So that is built up area.
This is not an NOC, this is one of the part of the document of the.
Right, but on the left side, at least some signature is appearing, chief executive officer, Guwahati
Signature is
Metropolitan.
there. Ultimately, what the NOC has come.
Checked by so and so.
No, what the NOC.
Veracity, we don't know the genuineness of this document, but on the left side, at least GMDA
The signature is there, madam.
signatures are appearing.
In fact, madam,
So
there are-
suppose open space, they have built wall, otherwise 70.52, 6th floor area, common built up area. Permission was granted. If we take this as a genuine document, subject to correction by your side,
No.
70.52, within that 144 square feet may come.
Yes.
May come.
May come, madam.
Then if he has, suppose instead of open area, he has built wall
Wall.
inside that water tank, suppose.
Down below the water tank.
Down below the water tank. So whether that will fall within compoundable or non-compoundable.
But that,
Additional floor is different thing, but otherwise built up area you have given.
yes. And compoundable, and page number 59, he has also given an application that if it can be
Compound.
compounded or not.
I
As an
think
abandoned caution, my lord, I have stated, my lord, as an abandoned caution, it was given. Even if, my lord, and my lord,
if it is supposed to be compound, I have found that GMD is compounding floor itself.
Yes, it can, if it is there, it can get damaged.
Even if, which is non-compoundable,
Non-
as per your building bylaws. I have
Additional
found-
floor is not
I have posted that case. I have posted this case to ask query from you.
No.
That even floors and floors are being compounded.
No, it cannot be, madam. The law doesn't, it cannot be. Madam. Law says-
Yesterday, one case came. I have granted stay because the builder is constructing one floor, you have already compounded. Then he is constructing two more. I have asked for instruction on 3 dates at the motion stage. No instruction is forthcoming. It appears, then you ask the authorities to stop demolition. Hard.
Well, in the
Get the
meantime,
records.
I have to apply one thing, my lord. In the meantime, my lord, demolition has started this afternoon. And my telephonic inspection, demolition is complete. Demolition is complete.
Demolition
It's
is
complete.
my lord, my instruction is that it was started, my lord.
Because
See, the
it's
correct
small.
144 square feet is not a hard, long
Almost
time.
One wall and aluminum sheet has been built.
No, my lord, my instruction is that wall was already there. The petitioner constructed an open for entry and aluminium.
Get the instruction, are you sure?
Telephonic is not, just now I have seen. Demolition exercise is over and the GMD officials have left it.
If that is so, then it is difficult.
Otherwise, my lord, I
If it is
understand.
complete, then
But my instruction is otherwise, my lord, that a part, whatever, my lordship, I have some photographs, my lord. Lordship may kindly peruse this. What has been demolished, my lord. My instruction is that not fully demolished. I have taken some fresh photographs, my lord, during the break time. Let only front side, there was a aluminium, my lord, aluminium structure. It was used as entry and ingress and egress. Only that has been removed and other walls, they are like that, my lord. They are still like that. The walls has not been demolished, my lord.
No, who will ensure what is the present
I'll
state?
give a report, my lord, possibly there.
If demolition is already done, is done.
Well,
So
my
let us-
instruction is
there
that
shall not
wall
be
has,
a-
Because he has purchased an open space. That's the fact, my lord. Now wall has come up.
the open space, definitely, my lordship
Otherwise, I will
knows.
not
No,
object him for.
we cannot ascertain what is there.
My lord.
At 4 o'clock.
Yes, my lord. Lordship will fix up tomorrow, my lord. I'll take the absolute instructions, my lord. Whether entire floor has been demolished or only, if the only aluminum part has been removed, lordship can definitely take into it whether that other part is still there, the wall bricks.
Mr. Bora, then you shall instruct, if not completed, stop
No,
the
it's not
timing.
completed. Also, issue status code, I have no difference. Status code, it can be given.
Status quo order is very difficult to interpret.
No,
Right? Mr. Chakraborty. T. Chakraborty, Learned Counsel for the petitioner. Mr. S. Bora, petitioners. Mr. S. Bora, Learned
paying for
S. Borua, Learned
phone number 2
Junior
and
Government Advocate Assam for the response number 1. S. Bora, Learned Standing Counsel, GMDA for the response number 1, 2, 3, 2 and 3. Full stop. It is a case of the petitioner that the petitioner or petitioners that the petitioners purchased a flat and flat area 1484 square feet from the
Respondent number 4, my lord.
respondent number 4 pursuant to issuance of no objection certificate for transfer of land stroke title by way of sale by the respondent number by the Deputy Commission, Kamrup Metro District on 21/10/2017. Full stop. As per the agreement, sale, registered sale deed, the petitioner was to be provided with a residential flat measuring 1340 square feet and an open set measuring 144 square feet flat in the second floor and an open set measuring 144 square feet in the sixth floor of the apartment concerned apartment building, sixth floor of block 2 of the concerned apartment, multi-story apartment building named Prakritik Nivas, along with 2 parking spaces. Full stop. It is the further case of the petitioner that on the sixth floor, the developer, that is the respondent number 4, had obtained permission for built up area, including common area for an area of 70.752 square meter. Within bracket, approx.
My lord, 759 square feet.
59 square feet. Full stop. After being handed over 144 square feet on the sixth floor, the petitioner constructed a room covering that area. Full stop. The petition number 1, petition number 1. The petitioner was served with a, where is that?
Well, initially, my lord, first one is at page 33 on 27th July 2023.
Do a show cause notice dated 27/7/2023 was shown to have been served upon the petitioner, comma, by the respondent's GMD authorities, comma, it is the case of the petitioner that the said, so-called notice dated to 2/11/2000.
211, madam, 211. Page number 31, madam, first paragraph.
2/11/2022. It is the case of the petitioner that the said notice dated 2/11/2022 was never served upon the petitioner, or was never personally served upon the petitioner. Full stop. On another notice, when?
My lord, the first demolition notice, my lord, at page 31, my lord.
No, that is gone. Then what?
Then, my lord, the impugn notice at page 62, my lord.
Huh?
Thereafter, I filed representations, my lord, which is at page 58 and 59.
Having received the knowledge about issuance of the so-called notice dated 2/11/2022, comma, the petitioner submitted representations before the
Respondent number 30.
respondent GMD authorities seeking demolition of the room at 6th floor in terms of the order passed earlier on 27/7/2023, and or to consider compounding of the construction. Full stop. It is a case of the petitioner that despite receipt of those representations from the petitioners on 12/10/2023, comma, the impugn order dated 12/12/2023 has been passed, whereby the petitioner has been asked to demolish the construction measuring 144 square feet on the purported ground that the said construction is unauthorized construction in violation of the approval and the provisions of the GMD Act 1985 and the zoning regulations and the building bylaws. Such demolition was ordered within a period of 5 days from the date of receipt of the order, failing which the respondent's GMD authorities would proceed with the demolition of the alleged unauthorized construction or sealing of the premises of unauthorized construction. Full stop. Mr. Chakraborty, law and counsel for the petitioner, submitted that the impugn order dated 12/12/2023 was served upon the petitioner only on 14/10/2023, and even before expiry of 5 days from the date of receipt of the impugn order dated 12/12/2023, comma, the respondent's GMD authorities have proceeded with the demolition of the construction of the 6th floor on the allegation that the construction was unauthorized. It is submitted by Mr. Chakraborty. It is further submitted by Mr. Chakraborty that the demolition work is only partly completed, whereas Mr. Bora, Standing Council GMD, has submitted that the demolition work is complete. Full stop. As the as this order is passed at 4:15 p.m. today, comma, this court, having regard to the projections made on behalf of the petitioners, comma, directs the respondent GMD authorities not to undertake any further construction, demolition from the moment from 4:15 p.m. both the parties shall provide instruction before the court on the next date of listing, that is day after tomorrow.
Lordship, in the meantime, whether standing council may be directed to bring the copy of the NOC, which I have stated that NOC was given. If that is produced, my lord, if it is found that NOC was there, then.
And otherwise, it is construction is open shed only.
Well, open shed, my lord, lordship knows. Nowadays, my lord, people purchase the open shed and for thereafter they use.
For construction, permission is required.
Therefore, they given
Apparently, it is unauthorized.
NOC has
Construction
been
is
given.
unauthorized.
Well, NOC
Whether
has
it
been
is
given.
compoundable or not, that is a question.
NOC
Get the
was given.
status first. We are not into that aspect, Mr. Chakraborty.
Lordship,
If the construction demolition is complete,
my lord,
everything is infructuous.
my lord, that is.
Why we should go enter into those? For that, you have to seek damage,
My lord.
not in a writ proceeding.
Yes, that is.
This is an extraordinary situation you have projected. That is why I have asked not to proceed further. Get the photographs at 4:15.
Lordship. Okay.
We'll proceed or otherwise we will close. If demolition is complete, we will close.
My lord, our recent photographs as of now, my lord.
Arbitrary action, you seek damage for that.
My lord. I'm deeply obliged.
16 and 17.
Hardly time, Mr. Sinha. That,
Placed in the first week of January.
what is that
Response number four has
secretary?
been Out of a.
Yes, ma'am.
Secretary, dispute secretary,
Yes, sir.
cooperative society.
Yes, ma'am.
Okay, when
First week of January.
you are one secretary and Mr. Goswami, you are another secretary. Okay. When? First week, it will be too crowded.
Second week, Lordship, just before the.
Or after Bihu then, man. Because in the inside, yeah, in the middle, Bihu comes, man.
23, 23 or 25. 23. Okay. Everything is complete otherwise.
Yes,
Yes, Lordship.
Okay. B. Sinha, petitioner. In 16
and 17 also.
and both the petition. And Mr. R. Goswami, Learned Counsel, Mr. S.K. Talukar, Learned Standing Counsel, Corporation Department for the State Respondent, and Mr. R. Goswami, Learned Counsel for the Respondent number 4 in 16 are present. As sought for by the Learned Counsel for the parties, these are the cases on 23. 1.
Item number 18.
Yes, Tiken Kolita.
Lordship, a week time may be granted to file affidavit in reply, your Lordship.
Okay. To which affidavit in opposition?
Lordship, both. Lordship,
Both?
Yes, your Lordship.
Okay. MS,
F and Jaman
F,
and Jaman.
and Jaman.
Yes, your Lordship.
Learned Counsel for the petitioner has prayed for and is granted 2 weeks time to file affidavit in replies to the affidavit in opposition filed by the respondent number 2 and the affidavit in opposition filed by the respondent of 7 to 11 respectively. Raise the case after 2 weeks.
Yes, your Lordship.
19 and 20.
Lordship, in 19 and 20, initially cases were filed because without compensation, works were continued in the national highway where the Pattadars. Initially, we were deprived because it was said to be a forest area. But now they have given an affidavit that this area was de-reserved. Therefore, Lordship, nothing remains. They have admitted to our claims. Therefore, the national highways should enroll us in the process of compensation. At least because in the affidavit, they have also written that they have also given letters to the national highway.
Yes, what is the stand? You are admitting.
My lord, In
Patalen.
my lord, in the 1965, my lord, the 360 hectare, my lord, that was deforested, my lord. But the gazette notification, my lord, of another 360 hectare was not issued by the government, my lord. So they are the residing of the 360 hectare of 360 hectare of land of 1965. We issued the patta.
65 non-gazetted or gazetted?
My
Tell
lord,
me.
that was gazetted, but again 1972, another three
No, forest was
de-reserved.
declared when?
In 1965, it was de-reserved. We have annexed the document in our
De-reserved, how many?
360 hectares.
Hectares.
Hectares. And
Okay.
accordingly, we issued pattas.
Pattas, and
But-
they are the
They are the
pattadas.
pattadas. But the forest department, at that time, my lord, they notified the area, my lord. And as per the, my lord.
Now question
government
is, whether forest was a transfer subject at bottom. when
My
that
lord,
time
it was
happened.
transferred subject from 1995, but it is
Then,
at that
then-
time, at 1965.
then how can retrospective?
My lord, we have not
No,
1965.
government of Assam has done.
Government of Assam.
There is a gazette notification.
Gazette notification is there, my
Government
lord.
of Assam has.
Assam done, my lord.
Yes,
And they have issued a gazette notification.
Gazette notification. is-
And they have asked us to issue the patta also, my lord.
Gazette notification of de-reservation.
De-reservation, my lord. Initially, it was issued, we have annexed it, my lord. It is in the 1965.
Lordship in nine.
Will be having
My lord.
paucity of time.
My lord, my lord. It
Yes,
is
it's
recording
difficult.
part.
Lordship,
Mr.
some.
Borua,
Lordship, initially we did not.
have you prepared your defense or not?
NSADCL is
Lordship,
recording.
Lordship,
Are
initially.
you prepared with your defense?
No, my defense is not required because I am appearing for NSA, no rule, but my learned friend is appearing, I think, on behalf of.
Who will pay the money?
Pays to be
My
by
lord,
NSA, I think.
3A notification is required to be issued, 3D issued, that has.
Yes.
Otherwise, if you are admitting his case, then money will be required
Money will be- And it is required.
and huge money.
My lord.
Mr. Borua will pay.
But they have to, my lord,
No,
there
for
will be, my lord, joint verification again by the NSADCL, Kala, Forest Department, and thereafter only it can be processed.
Right?
Kala has
That is
filed a-
why Mr. Borua also admits
know.
that we are not disagreeable to the ground situation. Then we can proceed.
My lord,
If he comes up with many pleas, then it will be difficult.
my lord, my lord.
You know, that-
I
Lordship,
wanted to understand what will be the next that
My
the
lord.
parties will argue.
My lord.
Okay. When?
Lordship, initially we did not pray for any status quo order since it's a
No,
public. work.
if it is, otherwise also I am not inclined. also. If it is a fact finding thing.
Yeah.
Earlier, your position was in cloud.
Yeah.
Now that cloud has been removed.
Yeah.
Now it is a question of money.
My
Yes,
lord, all notification. issuance of
notification, publication of the notification.
The process.
Process, my lord, process.
Final destination is money.
Money, my lord.
How much will come later?
It is how much? Okay. 22. We'll try to dispose of.
Lordship, one observation maybe.
What objection?
Lord-
We take up every case for disposal. Somehow or other, time does not permit.
Yeah.
BP Bora, petitioners in both petition. Okay.
Yeah.
Petition.
Both the petitions, Mr. J. Sutial and Standing Council, KAC, C. Borua, and Standing Council, NHAI.
That is for 2 and 7, my lord.
We are not recording the parties. Anybody else? Mr. N. Gusam, Land State Junior Government Advocate for the state respondents are present as the parties have submitted that exchange of pleading is complete.
Yes, they have filed the affidavit. So
NSA
since my claim has been admitted, I am not filing the reply.
You have
NSADCL,
submitted, yes, pleading.
NSADCL affidavit is required, my lord. What is their stand?
Oh,
They have not yet filed the affidavit.
okay. List the cases on 22/1/2023. The respondents, four. The respondents who have not filed their respective counter affidavits, shall file their respective counter affidavits if so advised. On or before the next date of this.
Item number 18, I am appearing for 5 and 6, my lord.
কোনো idea নাই।
No, I am not.
18, earlier.
একটু
18.
দুইটাতে NSA
No, 19, 20, 18, I appear. Wait, next meet they are going. That is
Say
5 and 6. Correct.
Okay, okay. See, লিখে দিব।
এই bill
item
number
number
সব নাইলে
18.
এই ও না
আগৰ
এই মহাবদমাশ আছে এনেছি দেখো প্রবলেম নাই
Yes, any interim order? Somewhere, any interim order is to be extended.
My lord, item 20 on my lord. My lord,
Interim order?
no, my lord. My lord, the respondent authority is supposed to file counter affidavit, my lord, within 3 weeks, my lord.
Ganguly,
Yes.
where is Ganguly?
Already, my lord, 130 days passed, my lord. They have not submitted any.
This is
affidavit.
regarding what? Freezing of bank account?
My lord, they have arised and question regarding the maintainability, my lord. So they're supposed to file affidavit, my lord. They intentionally delayed, my lord.
Involved is what?
It is regarding, my lord, an ATM center, my lord,
Huh?
regarding rent issue, my lord.
Regarding
Rent, area rent, my lord.
area. Okay, next year. Mr.
Islam, my lord.
J. Islam, learned counsel for the petition is present. The learned counsel for the respondent, PNB. Standing counsel, PNB, is found absent today on call. Post of let the case be listed after 1 week on a date to be expired hours. Yes, area rent.
But item 24 maybe.
Republic, my lord.
24, my lord, maybe February 1st week, my lord.
February first week. Okay.
Because
24, you are for respondent?
respondent, my lord, IGGL company.
I'm for the petitioner, for 25.
You might die.
Yes.
For the petitioners
We shall file the reply affidavit, my lord.
and J. Roy, learned senior counsel for the respondent number 5 are present. Yes, who will file reply affidavit?
Petitioner.
You'll file.
Yes, we shall.
Okay. Mr. Upadhyay, counsel for the petitioner has prayed for and is granted 2 weeks' time to file reply affidavit to the counter affidavit filed by the respondent. Raise the case on a date in the week commencing from 5th of February,
Well,
2020.
Lordship may record respondent number 6.
Okay, Mr.
N. Kalita.
And Polita. Vicky Bhawan, respondent number 6. Yes, Mr.
27 and 29, my lord. Lordship may fix it second week of Jan, next year, ma'am.
Second week of
Next year.
next year. Okay, 27, and release the cases on 10. 10 one.
Lord, may I please, Lord, sir? Item number 28, Panchayat matter regarding re-election of the president. This matter will become.
Item number
28.
28.
This matter will become infructuous on January 1. So if it is not decided before vacation, it will become infructuous.
Not possible.
But it may fix day after tomorrow.
We have already fixed many matters and this court will be rising because of other business early. So it is not possible.
May I place the
Why it will become infructuous?
Because for re-election, 1 month period is required.
Huh?
For conducting fresh election, 1 month tenure. should be-
Panchayat general election has been declared.
No.
Then
Fresh
there is
election.
no urgency.
Oh, from the first, let's say, from the first meeting, it is counted 5 years. So from the date of first meeting, it is only 1
Then
month.
everybody will go out. Everybody will go out. It is not only you. Everybody will go out. Is it not?
So, may it be clear?
No.
Lordship,
If-
for item 35, order. Lordship, this IA was filed.
Yes, madam.
Seeking for correction of typographical error. Lordship, prayer for liberty was prayed while withdrawing, Lordship, but liberty was not reflected.
Okay, will be
below.
considered next, not before vacation. I got a did you?
Lordship, second week of January.
Okay.
May I pray before worship regarding item number 36 of orders column. And
36 orders column.
in this IA, that means
What is the IA?
we are the partners evicted by the state authorities for which IA was filed for stay. proposed. Though, my lord, as we are the Kattadar.
Whether interim order was passed?
No, my lord, in this IA interim prayer is met.
No. When the writ petition was moved,
Yes, yes.
whether you asked for interim relief?
No, sir. No, my lord. At that time, step petition was not filed as there was some other issues regarding our Pata lands. For this reason, at this present time, so my lord.
Next year.
My lord.
First week.
Must.
Someday, fix a day. Huh? First week.
Must.